Michelle Jones versus David Lichtner.
For the record, this matter is before the court for purpose of reviewing defendant father's parenting time. This hearing is being conducted via Zoom. Are you Michelle Jones?
Yes, I am.
Right. Good morning, Ms. Jones.
Good morning.
Is David Lichtner present on audio? It appears that Mr. Lichtner has not appeared. This matter was scheduled for 8:30. It's now 8:45. Ms. Jones, when did Mr. Lichtner, has he been exercising his video calls with the children? With Connor?
Not as it was discussed that he was supposed to be calling twice a week. He has been failing to do that. I mean, he has attempted to make a phone call generally about once a week. And I mean, sometimes we're either busy, a couple times we were busy, or my son said he didn't want to talk. And I'm not going to force him. He was watching a movie. So I was like, whatever. But for the most part, no, he has not been calling twice a week like he was supposed to be.
Has the supervised parenting time commenced with family counseling shelter services, or are you still on the waiting list?
Still on the waiting list.
Okay, well, we'll keep on the waiting list, but Mr. Lichtner was present when we last heard this matter on April 3rd. He was aware that the matter was adjourned at that time to today's date. He was mailed a copy of the order specifying this matter was adjourned to today's date, 8:30, to review his parenting time schedule. But since he has failed to appear, the court will reserve his parenting time until such time as he petitions the court. Now, so he, court suggests stay on the list for family counseling child services. If they do reach out to you and they're available, maybe reach out to them. Obviously, the court would like to see kind of a relationship with his father, but obviously, if Mr. Lichtner is not willing to, if he's not motivated to develop that relationship, then it's not going to work. You can't force it. And obviously, this order that the court is entering today does not prohibit phone calls. So if he does want to talk with Connor, the court would suggest you permit that if it's reasonable, but there's no longer a court order that requires you to cooperate with that. But obviously, as Connor's mother, it's the right thing to do.
Mm-hmm.
Do you know if Mr. Lichtner is even employed?
Yes, he is. That's where he was this morning, was at work. And I recently just started getting child support again about a couple weeks ago. So I almost went 2 months without it.
Okay. So he texted him this morning and he said he was too busy at work?
He was at work and I said, did you forget about court? And he says, what court? So, yeah. He was not even aware.
The court's aware he's had a substance abuse history, but it's good that he's got a job that maybe will keep him sober. In any event, the court will reserve his parenting time until such time as he petitions the court. Both of you will be mailed a copy of this order, and there's no future court dates at this time. All right, with that, we can conclude this hearing, ma'am. Thank you for appearing, and you can zoom out. Have a good rest of the day. Plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Henry Levens, representing the plaintiff, Colin Heaney. And Mr. Heaney appears to be present with Mr. Levens. Is Anna Marie Wright present on audio? It appears that Ms. Wright has failed to appear. This matter was scheduled at 9 a.m. It's now almost 9:25 a.m. Mr. Levens and Mr. Heaney attempt to text Ms. Wright to remind her of our court hearing this morning.
In addition to that text reminder this morning, Your Honor, Mr. Heaney did communicate during his Sunday parenting time with defendant mother Anna Marie Wright, reminding her at that time as well of the hearing today.
Did she respond to the communication this morning?
No, Your Honor.
Okay. All right. This matter was adjourned from April 16th, at which time Ms. Wright was present. She was notified at that time that parenting time would be reviewed on today's date and time, but she's failed to appear. She's not contacted the court. The court has received the following recommendation this morning from Mr. Walker. Father's parenting time should be every Tuesday and Thursday from 5 p.m. to 8 p.m. and every Sunday from 12 noon until 7 p.m. Father shall provide all transportation. Parenting time shall be unsupervised. Currently, parenting time is supervised at mother's home. So it appears to be the same schedule,
Yes, Your Honor.
relatively, but the only change is that the parenting time is unsupervised. Further, it's recommended that the mother shall provide her information to Attorney Levens or for him to prepare a verified statement. The verified statement is for what, child support purposes, Mr. Levens? What do you need the verified statement for?
That's correct. At our last hearing back April 16, the matter was referred to the front of the court for a support recommendation. Since that time, defendant mother has refused to provide essentially her social, driver's license, occupation, and birth date to facilitate that review, despite being asked numerous times.
Good morning, Mr. Walker. Do you know, did mother respond to the front of the court as part of their investigation? Don't they reach out to the parents and ask them for a copy of the recent pay stubs and copy of maybe the last tax return?
Your Honor, the verified statement is required for the front of the court to open a case and then start the child support investigation. So I believe the front of the court has not started the investigation yet because that verified statement has not been provided.
Okay, so obviously if mother does not cooperate and provide the verified statement, then there will not be any child support recommendation, correct?
Correct.
Is that correct, Mr. Walker?
Yes, Your Honor, that is correct.
Thank you. All right, it's further recommended that the parenting time be reviewed on November 5, 2024 at 9 a.m. All right, Mr. Levens, is this recommendation agreeable with your client this morning?
It is, and I don't know if I didn't hear the court. We were also asking for the order to have it such that the minor child, Cecilia, is put under plaintiff father's insurance through DTE or at his work.
That is correct. I do see that, Mr. Levens. I neglected to add that. The recommendation does say father shall add the minor child to his insurance. Well, Mr. Levens, you wish to voir dire Mr. Heaney regarding this recommendation this morning?
I'm sure you've heard all the terms and conditions of the proposed rec placed on the record.
Yeah.
And you wish the court to enter into order to adopt these recommendations.
Yeah.
And then for the record, you have been exercising your supervised parenting time.
Yeah.
And you've made all of those visits except for 1 week when you were under the weather.
Yeah.
And those visits have gone well.
Yeah.
And you're greatly enjoying this new opportunity being a dad.
Very much.
I have nothing further, Your Honor.
Thank you, Mr. Levens. The court will adopt the recommendation. And
Thank you.
We will see everyone in November.
Right. Thank
All
you,
right, that will conclude. You can zoom out. Have a good rest of the day.
Yeah, likewise, everybody.
For the record, this matter is before the court on the plaintiff's motion for to show cause directed to the defendant, Robert Tadson. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski representing the plaintiff, Denise Tadson. Ms. Tadson is present. Is Robert Tadson present on audio?
Yes.
Tadson. This request of the plaintiff Denise is to enforce terms of a judgment of divorce regarding some financial obligations. The parties have conferred with Mr. Pratt from the front of the court. The court has received the following recommendation that the 2022 tax liability shall be paid by November 1st, 2024. We should probably reference who that's to be paid by. It's to be paid by the defendant, Robert Tadson. Is that correct, Ms. Zagorski?
It is.
And further, Mr. Tadson will pay to Mrs. Zagorski attorney fees incurred for today's motion and hearing within 14 days. Do we need to specify an amount?
Judge, we talked roughly about what it was to date. I didn't know how long we would be on the record. So Mr. Tadson has a ballpark and I'll send him a complete invoice.
Okay. Do you have a ballpark figure? I mean, talking a couple $100? We're talking $1,000? What are we talking about?
No, it's approximately $300.
All right. Right, Mr. Tassin, do you understand the recommendation today?
Yes, Your Honor, I do.
Do you have any objection to the court adopting this recommendation?
No, Your Honor, I do not.
So in the meantime, if Mr. Tassin is given to November 1st to pay the remaining IRS tax liability for 2022, is IRS going to garnish funds from Ms. Denise Tatson?
No, we don't expect them to take any action against her until she files her taxes for 2024. And under this new order, the obligation will be satisfied in full and she won't have any effect when she does.
Okay, so Mr. Tatson, you need to provide documentation when it's paid off. You don't need to wait till November 1st.
Yes, Your Honor.
Once you have it paid off, provide documentation to Ms. Tatson or Mr. Gorski. What about the Bank of America Visa?
That is paid in-
addressed?
Your Honor, he has paid that in full and he also made my client whole from the refund that was applied to the 2000 in taxes that was due to her. So he has paid her what she lost from that as well as paid off the Visa.
Okay, and we don't expect any further losses, but obviously this does affect Ms. Tatson's credit though, does it not?
I don't know that it's reported to her credit report. I honestly don't know that.
I don't think so.
Okay. All right, Ms. Gorski, this recommendation is accordingly agreeable with your client. Is that correct?
It is.
Mr. Tatson, we'll be back in court if this is not paid by November 1st. We don't want IRS taking tax refund from your former wife once again. Do you understand that, sir?
Yes, Your Honor, I do.
The balance is about $5,000. Is that correct?
Yes.
Okay. And obviously you're paying a penalty or an interest, Mr. Tatson. It's your best interest to get this paid off as soon as possible.
Yes, Your
Right,
Honor.
Ms. Gorski, is there anything further, or do you wish to wire dear Ms. Tatson regarding this recommendation?
I don't need to. Thanks, Judge.
Right, Mr. Tatson, do you have any questions for the court?
No, Your Honor.
Did you contact the Postal Service to have mail forwarded to you?
Yes, and I've also
Okay.
changed it with the state.
All right, well, this is gonna be mailed to you at your address of Riverview Court, and hopefully the Postal Service will send it on to your way. Do you have any questions, sir?
No, Your Honor.
Mr. Tatson, any questions?
No, Your Honor. No, sir.
All right, court will adopt the recommendation. That will conclude, somebody can all zoom out. Have a
Thank
good
you,
rest of
Judge.
the day, everyone. Thank you. For the record, this matter is before the court and the defendant father's motion for alleging a parenting time violation, seeking costs and attorney fees. This hearing is being conducted via Zoom. Present is Attorney Timothy Churchill, representing the defendant petitioner, John McCarter. Ms. McCarter is present. In addition, Attorney Marie Zagorski is present with the plaintiff mother, Catherine McCarter. Good morning, everyone.
Good morning.
Morning, Your Honor.
Court also notes that there is Mr. Churchill filed an objection to a friend. The court recommended order to be scheduled to be heard on July 10th at 10:30. I'm not sure if that's before this court or the referee, but it's noted on the court's docket regarding I believe it's recommendation that recommend issuance of a bench warrant due to outstanding child support arrearages. Can that issue be addressed today as well, so we don't have to come back?
Your Honor, it appears we may have to come back anyway because they're requesting a evidentiary hearing on my motion. And if that's the case, I would move to consolidate the other matter with whatever date we come back, so we're not coming back twice.
Well, we'll just leave that on July 10th then. The parties can deal with that. I mean, I think it's just a matter of Mr. McCarter meeting with the front of the court, addressing some of those rearages and asking that the bench warrant not issue because apparently, I know there's some snafu with him appearing on Zoom.
Yes,
Yeah, the parties have met with Ms.
Mr. Ron.
Patrick this morning. Ms. Patrick, do you have a recommendation for the court this morning?
I do, Your Honor. I'm in the process of uploading, but I can read it to the court. The recommendation this morning is as follows. Motion for parenting time violation be dismissed. That's the extent of the recommendation, Your Honor.
Okay. All right, so Mr. Churchill, The allegation was about the Thanksgiving 2023. Apparently father made arrangements to go to California for parenting time with the children, and that did not occur. That's the primary basis of your motion. Is that correct?
That and the Christmas, he was deprived of any time at Christmas. The judgment basically guaranteed him 1 week at Christmas every year. And the modified parenting time order continued that. And he got no parenting time at Christmas this year.
Let's do it one holiday at a time. Let's try to get to this. Let's deal with, first of all, the Thanksgiving of 2023, then we'll move on to Christmas 2023. Thanksgiving 2023, that was obviously mother's holiday, correct? Because dad has Thanksgiving on even years. Okay. But your position is that mother had agreed to arrangements. Mr. McCarter expended funds unnecessarily, and then the last minute was denied. Is that your position?
That is correct, Your Honor.
Well, maybe needs to get that in writing. Reach out to you and get a court order addressing that before he incurs those expenses. It was mother's holiday. Obviously, that's mean spirited. If mom's lead them along and then all of a sudden pulls out the rug out from underneath them, that's mean spirited. But again, to what extent is a violation of a court order, Mr. Churchill?
Well, they made alternate arrangements that she basically reneged on after he paid everything he was supposed to and made arrangements, and the kids had called and confirmed through emails with their dad, hey, this is great, they're coming for Thanksgiving, and it didn't happen.
Understood. I read all the pleadings, and again, as I said, it's mean spirited, wrong for mom to pull out the rug out from underneath them, but how can the court find it to be a violation of a court order?
Well, they made an agreement that deviated from that. They didn't put it in writing. There's emails going back and forth on this, but it's only part of what's going on here. Then at Christmas time, nothing.
So let's say Mrs. Gorski, what's your response to the Thanksgiving? Then we'll go on to Christmas. Again, obviously, sounds like Miss McCarter pulled the rug out from underneath. I'm letting them to believe it's okay. Come out. I'm going to be busy Thanksgiving. Ms. McCarter incurred all these expenses unnecessarily. Why did she? What's her response to all that?
Yeah, thank you, Judge. And I apologize that I didn't file a response. I got Mr. Churchill's motion on Friday, realized it was in Friday's mail yesterday, reached out to my client and said, you have to be in court tomorrow. I don't know how Mr. Churchill got a date so quickly. I know how busy your docket is, but the envelope that it was sent in was stamped June 5th. So that's why you don't have a response from me with attached exhibits showing that Mr. Churchill's allegations are categorically false. And as you know, Ms. Patrick is the parenting time coordinator on this case, and she knows the truth, which is, I think, the reason that she made the recommendation that she did. We would call my client's father as a witness. Mr. McCarter, you're right. It was her holiday, and my client still cooperated when Mr. McCarter came out to California, and he still had access to the children at Thanksgiving. He didn't show up when he was supposed to. He communicates through Gabe, which is also a violation of this court's order. There's an order from last year that says he has to give 7 days notice. He doesn't do that either. But regardless, she made the children available, and he didn't show up when he was supposed to. And if we have an evidentiary hearing, that's exactly what the evidence will show. That's my response.
The court forgot that Ms. Patrick agreed to act as a parenting time coordinator. So, Mr. McCarter, did he address any of this through Ms. Patrick?
There's email.
The parties did communicate about Thanksgiving through Ms. Patrick, Your Honor. Yes, they did.
So, is that correct, Ms. Patrick? So, you were involved in the discussions around this Thanksgiving?
I am in possession of an email thread that started on November 18th by Catherine, who said that she thought she might be in Michigan for a family funeral. She might bring boys with her. She wanted to let John know that. And so I forwarded that to Mr. McCarter. I did not receive a response from Mr. McCarter. Well, then Catherine let me know that she decided not to take the boys with her, and that Mr. McCarter had been reaching out to the boys about getting them next weekend. Mr. McCarter did not contact me. Let's see.
That seems to be the issue, Mr. Churchill. Mr. McCarter needs to work through Ms. Patrick. Again, the court does not see, the court's not convinced with a violation of a court order. It's there's communication between the parties. If they communicate through Ms. Patrick, we can minimize that miscommunication.
I did Your Honor, I did communicate to Miss Patrick, and I did let her know that I was coming to get the boys. Me and my wife communicated both back and forth through the court, so I'm not for sure how Mrs. Patrick sitting here saying that we never communicated. We came to an agreement on what day I was supposed to pick up the boys. When I went there to pick up the boys, she did not open the door and she did not release them to me. The same thing that's been going on since Christmas, all the way up until this point. Well, now it's getting to the point where I have to get the police just in order to pick up the boys. This is totally inaccurate.
Your Honor, would you like me to respond?
Please, Ms. Patrick.
So I have an email on the same chain, November 22nd, that said that Mr. McCarter was contacting the boys and that they had worked out a schedule. The only email I got from John was on November 22nd saying, I gave my itineraries to what date and what time I plan on picking up the kids. So,
yes,
but that information was not given to me, Your Honor. He goes through the children. I found out because Catherine told me that's what the boys told her. And then on November 23rd, I got several emails from Catherine saying, is John coming? The boys haven't heard from him. I need to know to get the boys ready. At 4:25 p.m. on the 23rd, she emailed me and said that John has not shown up so far. Then on November 25th at 1:17 p.m., she emailed and said, I'm okay with John picking up the boys and bringing them back Sunday. He seems to want a written confirmation as he said he would come last night and didn't. I only received one response from Mr. McCarter, and that was that he had already given his itinerary and schedule, and I would assume that he gave it to the boys. And I would also like to say, Your Honor, I have never communicated with his wife, nor have I gotten emails from his wife.
Your Honor, I would note.
Okay, well, let me.
Mr. McCarter, Ms. Gorski.
Judge, your order of March 14th, 2023 says, father shall not arrange parenting time through the minor children. And he continues to do that. My client reaches out to Ms. Patrick and tries to work cooperatively. Mr. Carter will not.
That is not true. Show me, just because Catherine comes in and says these allegations, show me proof that I've actually contacted with the boys, because I have not done that. She's making these false allegations. I have not. I sat back and waited for Catherine to respond back to me on what time we're supposed to pick up the boys. There is no email saying that she's going to show up with the boys. I would not go out there and spend all this money to sit there and wait for my boys in California when I can be at work, just to sit there and say I'm communicating with the boys or I'm not coming to pick them up. It makes absolutely no sense whatsoever. So stop with the lies. It's very clear that she did not respond back to me at the time I was supposed to pick up the boys. She did not answer the door when I went there at all. She did not even bother to send an email to let me know that she was not going to show up at all.
Well, from now on, Mr. McCarter, you have a parenting time coordinator. Ms. Patrick has agreed to act in that capacity. You need to go through Ms. Patrick. Don't communicate or email Ms. McCarter. If you want parenting time at a time that's not permitted by court order, you make those arrangements through Ms. Patrick. So there's no miscommunication. Obviously, there was a miscommunication. Ms. McCarter says that she was agreeable to it. You didn't show up on the time that
I did, Your Honor.
Agreed. I don't know what the last communication was, but the court does not find there's violation of any court order. And you need to communicate to Ms. Patrick. So let's move on to Christmas. Mr. Churchill,
I did.
Who had Christmas 2023?
He always has a week at Christmas. It's in the judgment. In the last amended order, he gets 1 week at Christmas. Last year, he got no time at Christmas.
Okay, and that was to be in California. Is that correct?
Pardon, Your Honor, I couldn't hear some.
That was to be in the state of California, correct? The Christmas?
Well, it could be wherever they wanted it based on arrangements and agreements. The judgment originally said in California, but the modified order gave him a week of Christmas regardless and relied on the provision in the judgment.
Okay. And Mr. McCarter was required to give 7 days notice for his Christmas break week. Did he provide that?
I think it's 3 days notice under the amended order.
I'm looking at an order that was entered on November 7th, 2023. It said defendant shall give 7 days notice for his Christmas break week.
Okay.
The last order by this court. Ms. Patrick, was there communication through you regarding the Christmas week that Mr. McCarter wanted?
There is, Your Honor. And Catherine started on December 6th with a proposal of having the boys travel to Michigan for the Christmas break. She gave Friday, December 29th to January 5th. Mr. McCarter responded on December 18th that he would like to see the boys on the 29th of December, but he was going to be unable to keep them until the 5th. and they'd have to fly back out on the 2nd. And then we have more emails that started on December 20th, stating that mom was not gonna be able to accommodate that schedule, but however, she could probably have a friend keep them until the 5th when she would have them fly back based on the cost of the airline tickets. So then he responded on the 20th that that was fine with him. And that if they were going to stay a little bit longer, that he would like to visit them during that period. Then we had another one on the 21st. Says that she had made arrangements for them to spend time with their grandmother. So sounds like she wasn't sure she was going to be able to accommodate that. Then on December 22nd, we have Catherine saying she's trying to book the flights, that Mr. McCarter needed to contact Delta Airline and give him his driver's license and the address on his driver's license so that the boys could be registered as unaccompanied minors. Then on the 27th of December, Catherine contacted me saying she still did not have an address from John. And they had not made the arrangements with Delta. On the 28th, John responded that you need to provide a date and time as when my boys will be coming into town before I go and book anything. He then gave me an address of a hotel in Farmington Hills on December 28th. On December 28th at 5:14 p.m., I received an email from Catherine saying the boys are not flying back to Michigan because Mr. McCarter refused to provide the basic information needed to book the boys' flights as minors.
That's correct, Your Honor. The airline requires the address of Mr. McCarter's identification so that they can verify that he is authorized to retrieve them from the airport. He cannot provide a hotel address. The airline will not allow the children to fly to somebody who provides an address of a hotel. They need to know the address on his ID. And he plays this game. In fact, today he has the children and he's supposed to be at that hotel in Farmington Hills. But when we asked him this morning where the children were, because we were worried they were in his back seat, he said they're at a hotel in Southfield. It's like a shell game. He just moves everything around. So they weren't able to fly. Couldn't book the tickets because she didn't have an address.
Right. How does the Delta know whether or not it's a residential or a hotel address? How would they know that?
They asked for his driver's license. She has to provide the address when she books the flight, and then they look at his license to confirm. So he gave her a hotel address. Unless he's living at that hotel and it's on his driver's license, it's not going to work.
Okay, that's not what you asked for me to call.
I'm sorry, hold on just a minute. How did the children get here if Mr. McCarter was unable to provide a driver's license with a residential address?
They didn't come. She couldn't book the flight.
Oh, I thought you said the children were in Southfield today.
Oh, they're here right now. Yes. And they are with
How did they get here
right now?
How did they get here if Mr. McCarter didn't provide a license?
They flew with their mom. They flew with me.
Okay, understood. All right, any response to Mr. Churchill, Officer Mr. McCarter's guy needs to accept some responsibility, significant responsibility for these snafus, which is most unfortunate.
Your Honor, that is not what they asked me for. She asked me for an address.
Mr. Churchill, is there anything further?
Your Honor, I think there's more to it than that.
That's not it.
21st, she's making arrangements for them to be with her mom during the holidays when everything broke down during the holidays. She had no business making other arrangements during the holiday other than to try to facilitate his parenting time.
I would agree. Ms. McCarter, this is for dad, not your parents. This is between the parents. But again, obviously, the bottom line was Mr. McCarter didn't provide a copy of his driver license with his address. That's
Your Honor, that they never.
But the court would agree, Mr. McCarter should not be interfering in scheduling time for her parents. This is not for parents. This is for dad. But the court does not find there to be any parent time violation. So the court's going to adopt Mr. Patrick's recommendation.
Your Honor, they never
denied at this time.
Your Honor, they never asked me for an address to provide to the airline. So this is a bunch of hogwash. They asked me where was I going to be keeping the boys at. They never told me to call a airline. She never provided an airline number. She never sent an email. And I like for Mrs. Patrice to produce these emails that she's saying that she sent to me, asking me to call an airline to provide an address, because that is totally not true.
I forward all emails from Miss McCarter to Mr. McCarter. I have those emails and I can produce them anytime the court would
Okay.
like to see.
And
them.
you asked me to call an airline and provide them with an address, is what you're telling me right now.
If you could
Ms.
also copy
Patrice?
Mr. Churchill with those emails, Ms. Patrick.
Yes, Your Honor.
They asked me where was I going to be staying at. They asked me for an address. I sent over the address of where we're going to be staying at. They never asked me for an address or send over an identification or a picture ID of my identification, or told me what airline they're coming in on and for what, and sent the number, any information for me to call this airline to provide anything. This is a bunch of hogwash. And Mrs.
did you-
Patrice, shame on you.
It's a week at Christmas. It's in the judgment every year. You'd think she would do what she could to facilitate that instead of.
She did. She did.
Wow.
And even when the kids got in town yesterday, he had to go through the police to get them.
He did not.
I did. Yes,
He
I
did
did.
go to the police, but he didn't have to.
Yes, I
He
did,
didn't
because
have
you
to go to
never.
the police.
Yes, I asked for the kids on the 7th. You sat there and dropped the kids off at the house, at their friend's house. They spent the night over there, and I called the police because you wouldn't give them to me on the 7th. You never responded me to confirm with me on the day on the 8th to pick the kids up at 8 o'clock, nor did you provide an address. These are the tactics that she's continuing to play every time I go to pick up the kids, just like you did it during Christmas time, which is a complete lie. I'm not spending money to go way out to California just to have her tell me that I didn't show up, which is a lie. I showed up during Christmas to pick up my kids. She never answered the phone. Just like now, when I came to go get the kids on the 7th, she never showed up. She never confirmed. I had to call the police to try to get the kids from her. And then she actually ignored the police officer. We went to go confront her. She just pulled off away from the police as well and told the kids that she's going to Canton, Michigan. I went over to try to hunt her uncle's house down through the kids to find out where they were at. They said they were going to Canton. They never showed up there. She took them to the Sky Zone, stayed there with them all day long. And then finally, her uncle had to call her twice on the phone to get her to bring the kids over to the house.
How long are the children here in Michigan, Ms. Gorski?
8 days, until when? Friday?
Really Friday. morning.
They're with their father right now. Mr. McCarter, where are you staying with the boys right now?
26. And the reason why I'm staying here is because she never confirmed my booking on the 8th to pick up the kids. So therefore I had to cancel my reservations at my last hotel. I had to give those up because she never confirmed me picking up the boys, or never even provided an address for me to get the kids. These are the shenanigans that she's constantly doing. She actually went in there. Remember, Judge, she actually told the counselor at the social worker that there was no bond between me and the kids. The social worker came back a complete lie and said that's not true. These are the tactics that Catherine is going to continue to lie, the same way she lied to the FBI, that these things are not true, and they are true. I'm not getting the police involved to pick up my boys or to try to hunt them down. I should not have to do that through Monroe and all the way to Canton just to get my boys when she knows that she's supposed to turn them over to me. When she's here in
Michigan. The boys are until Friday.
A lot of history here. I don't think the judge needs to know all that, but I would only.
The boys are here till Friday.
Remember,
Yes.
2 years ago.
Yes.
They were in Michigan.
What about the boys staying a little bit longer? I mean, obviously, mother could be a little more cooperative on all this and working with dad a little more on this parenting time. Why can't the boys stay a little bit longer?
So let me explain what's actually going on right now. So the boys wanted to come back to Michigan to visit their grandmother, their father, their friends. And
Right, they can do that another time.
because
This is dad's parenting time, and Mr. McCarter, so the court doesn't want to hear that. Mr. McCarter, what's your schedule? Do you want us to see the boys a little bit longer?
Right, so he's gonna pay for half the flights
Well,
then. I don't know.
Well, I can't. Well, I can't, Your Honor, because I was not able to make arrangements because she does not respond back after she makes appointments.
Right, so
No,
you're not able to work with your work schedule to spend any additional days with the boys. Is that correct?
Absolutely, Your Honor.
All right. Okay. Again, the court will adopt Ms. Patrick's recommendation. The court does not find to be any violation of the parenting any order of this court. but the court would say, shame on you, Mom, for not working more with Dad. Mr. McCarter, shame on you for not communicating effectively with Miss Patrick. And you went to Miss Patrick. So with that, the court will conclude this hearing, and you can all zoom out.
Thank you.
This is a bunch of bullshit.
That's noted for the record, Mr. McCarter. They'll remember that next time. You don't use this language in this court. So Mr.
Well,
McCarter,
because it is, because
long before you come back before the court, please zoom out to Mr. McCarter, please. Silence him. Thank you, Ms. Patrick.
Your Honor, just, and I know the court knows, Mr. McCarter is very abusive when.
Sir, could you please state your name for the record?
Michael David Duval.
All right, for the record, Mr. Duval is appearing this morning via Zoom from the Monroe County Jail. Also present is Monroe County in front of the court attorney, Rebecca Hicks. Mr. Duval, what is your current mailing address?
Honestly, sir, I don't know that exact numbers, but it's the name I live with my dad.
Okay. It's on the South Dixie Highway.
Yeah.
Are you currently employed?
No, I have been looking for a job. I had found one, and I told my PO, and unfortunately I can't work there because I can't work with or be around my girlfriend right now. They got us apart, and she works there too, so I had to leave the job. So I've been looking.
Mr. Val, the front of the court is a 4-page list of employers that are screaming for employees. So you need to come out front of the court and get a copy of that list. The Michigan Bar is hiring dishwashers. You get your job today, Mr. Val. You're not being very motivated about seeking employment. There are jobs out there. In event, Ms. Hicks, can you provide the court some information regarding Mr. Duval, please?
Yes, Your Honor. This is an arrears only case. It stopped charging in May of 2021. The current balance is $3,901.93. We last received payment in June of 2021. There is a previous finding of contempt. It's from November 16th of 2015. It is a first finding, and there is a 31-day balance. Looking at the history of this case, Your Honor, it appears that during the majority of the past show cause hearing dates, Mr. Duval has been incarcerated in the Monroe County Jail on unrelated matters. So we just kept adjourning to monitor the status of his incarceration for some time now.
All right. So, Mr. Duval, you understand you got arrearages about almost $4,000. They're not going to go away. You need to chip away at those.
Oh, I agree with you, Your Honor.
You've not made a payment since June of 2021. That's 3 years, Mr. Duval. You've not made a payment 3 years.
Yeah, I understand that, sir. I've been having some mental health problems and stuff like that too. I do have an appointment to see a psychiatrist, and I got all that set up.
Okay.
I really am trying to get back to where I was. I mean, as you can see, I mean, my daughter is grown up now, and I kept up with it until I started having some issues.
Okay, well, make an appointment with community mental health, Mr. Duval. Get your life and your act together and your life in order so you can secure some meaningful employment.
I do have an appointment with him on the 18th.
Okay. Well, you got 31 days hanging over your head. Do you understand that?
Yes, sir, I do.
Are you being held in jail on any criminal charges or probation violation?
No, just this.
Okay.
I mean, I've been seeing my probation officer and everything. So, and a peer coach, I've been seeing her, so she's been helping me. So
do you own any property of any value? Do you have any bank accounts?
No, I don't. I mean, if I had bank accounts, I'd paid that.
Have you applied for Social Security if you have a mental disability?
Well, not yet. That is my plan.
Okay. So will your father post a bond? This is where you reach out to your family and friends to post a bond on your behalf.
Nobody has bond money for me. I mean,
well, your dad's putting a roof over your head. He's feeding you, correct?
no, the state has been helping. I don't take my dad's money.
Well, but he's supporting you, correct?
Well, he lets me stay with him, yes.
Okay. Well, Mr. You got to reach out to family and friends. Ms. Hicks, do you have any questions?
I do not have any additional questions, Your Honor.
Any recommendation for the court, Ms. Hicks?
At this time, Your Honor, it appears like that it would be appropriate to sentence him to some period in jail. I was just trying to scroll back through my enforcement orders. It appears that the last time that I had him at a hearing where he was not in the jail was September of 2022. At that time, he had been ordered to come in, pick up the jobs list, apply to so many jobs per week, and then he failed to appear at the next hearing and ended up in a bench warrant, Your Honor. So at this point, I'm just kind of at a loss as to what the front of the court can do to facilitate payments on this now arrears only case.
Okay. Then just keep him on a short lease. Mr. DeVal, when were you arrested? Last night?
Last night, yeah.
Before midnight or after midnight?
Before.
Okay. All right. Mr. DeVal, anything you want to say before the court imposes a sentence? We need to get your attention. You need to get a job, cut grass. Go to Jack's Lawn Service. There are jobs out there, Mr. DeVal. You need to get off your rear end.
I understand that, sir. And
anything you want to say?
I am pushing. I promise I will. Excuse me, I couldn't hear you.
Mr. DeVal, your promises are worthless because you don't follow through. You have not made a payment, not a dime since 2021. It's 3 years ago, Mr. DeVal. It's the sentence of this court. You serve 31 days in jail as follows: 10 days immediate. You give him credit for the 2 days you have served. So you're going to serve the next 8 days in jail, but you can be released upon posting a $500 cash bond. So reach out to your dad, see whether you can post $500, and it's applied to your arrearages. If you're not, you think your dad can post $300? Give me a figure, Mr. DeVal. Can you come up with 300?
I have nobody to post anything, sir, or I would have been doing this. I've got some mental health problems I need to go take care of, and you guys want to hold me here. I got to be somewhere at the 18th to get that fixed. So I don't know what to say. I'm sorry. I've always paid on that until I got sick, and now I'm here. I had a job for 20 plus years at the same place. I totally understand I need to, but holding me here ain't getting my help if I'm here.
All right, Mr. DeVal, let's talk about what time's your appointment on the 18th? That's next Tuesday, correct?
Yeah, I mean, I ain't got my stuff in front of me to tell you what time it was.
Where's your appointment? Is it with Community Mental Health?
No, I got to go to ProMedica over on Stewart Road and see my doctor there. They have a psychiatrist there that's going to see me.
Okay. So you have an actual appointment on the 18th of June. Is that correct?
Yes, sir.
All right. Well, the court will shorten that sentence so you can have that appointment. It's important you have that sentence. But you were told a couple of years ago, come down in front of the court and get that job list. So when you get out of jail, you walk across the streets in front of the court and get that job list. Do you understand that?
Yes, sir.
Okay. You didn't do it last time. So we're going to give you the court's going to modify the sentence so you can be released by then. So what kind of sentence we need to impose so he can be released on the 17th on Monday?
How many? He gets 2 days credit?
Correct.
So you could do 8 days immediate credit, 2 days, right? 1, 2, 3, 4, 5, 6, 7.
Let's do 6. All right. The court's going to modify sentence and you order to serve 6 days in jail. You give him credit for the 2 days you have served. So you got 4 days in jail or a $500 cash bond. So reach out to your dad. I mean, this applies to your arrearages. You can pay him back when you get a job. You can be home for dinner tonight, Mr. DeVal. So, but if you can't post bond with this sentence, you'll be released on Monday, the 17th. So you go to that appointment. It's very important you keep that appointment.
Yes, sir.
And then in the same day, when you get out, come to the front of the court and get that 4-page job list. You got to start making some payments. If we're going to give you a date, we're going to give you a date. You need to prepare for Ms. Hicks. And the copy of this order will be sent over to the jail. Do you have an address, Mr. DeVal, in South Dixie? Ms. Hicks?
I do not, Your Honor. That's not the address that we have for him.
So Mr. Val, when you come to the front of the court, do two things. Get the jobs list and also fill out a form with your new address. So have your dad write down the address for you so you can have it written down when you come to the front of the court to that job list. You fill out a form so that you got your address so they can mail you these orders so that you'll know about future court dates. Because if you don't know about them and you miss them, bench warrants will issue. So we're going to give you a review date sometime in July.
How about July 16th at 10 a.m., Your Honor?
Okay. All right, Mr. Val, you are to appear before Ms. Hicks on July 16th at 10 a.m.
Okay.
If you don't appear that date, a bench warrant's going to issue for your arrest.
I will be.
And you've got still got time hanging over your head. You can avoid any additional jail time if you just get back on board. But yes, make sure you keep that appointment on the 18th, Mr. Val, with ProMedica. And then come into the front of the court, get your jobs list, and change your address. So you have a mailing address. So a copy of this order with this date, July 16th at 10 o'clock, will be sent over to the jail. You get a copy of this when you're released. So you got the next 4 days in jail, but you can be released today upon posting $500 cash bond. So reach out to your family and friends, see where they can help you. Because this applies toward your rearages. It's not going to fines or court costs. It's going to reduce your rearage by $500. Any questions, Mr. DeVal?
No.
Okay, you can step out. Thank you, Ms. Hicks.
Thank you, Your Honor. I'll get that order prepared and uploaded shortly.
For the record, this matter is before the court for hearing on the plaintiff as well as defendant's motions for temporary custody, parenting time, and child support and other relief. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff. The plaintiff, yes. The father is Zachariah Garcia. Mr. Garcia is present. In addition, Attorney Eric Clark is present representing defendant mother Michelle Garcia, and Mrs. Garcia is present with Mr. Clark. Good morning, everyone.
Good morning, Your Honor.
The court also noted in reviewing the file for this motion hearing that a pretrial conference is scheduled on June 28th. And the court thought if we have everyone here today, perhaps we can conduct that pretrial conference today and move this matter forward to mediation with the continued pretrial conference thereafter. The parties have conferred with Mr. Walker for the front of the court, who has provided the court with a fine recommendation that the parties shall, on a temporary basis without prejudice, share joint legal custody. Physical custody is reserved. Parenting time for fathers shall be as follows. Fathers shall have parenting time every Monday after work to Tuesday morning, and every Friday after work to Sunday morning. Fathers shall also have every other Sunday until 5 p.m. Further, fathers shall pay all marital bills until further order of the court. In addition, fathers shall pay $350 per week directly to mother for groceries and other expenses until further order of the court. Father shall not be allowed to purchase a home. He shall not use the marital funds to purchase a home. Father shall add mother as an authorized user on the Navy Federal credit card. Mother shall not use the card. The issue of payment of attorney fees shall be reserved. Finally, the party shall mediate with Mr. Walker on August 1st, 2024 at 1:30 p.m. and appear for a pretrial conference thereafter. That is a recommendation. Ms. Nemec, is this recommendation agreeable with your client this morning?
It is, Your Honor.
Mr. Clark, is this recommendation agreeable with your client this morning?
Yes, Judge.
Just a clarification, do we need to clarify what dad's parenting time on these alternate Sundays until 5 p.m.? I just want to make sure everyone's on the same page. Father shall have parenting time every Monday after work, so everyone knows what time that is, correct? And then you can agree upon what time the child will be returned to mother on Tuesday morning, and also every Friday after work till Sunday morning. But every other Sunday, the parenting time will be until 5 p.m. So the parties will be able to communicate in terms of what Sundays.
They are already They're already exercising every other weekend parenting time. So I believe it's the intent that that additional Sunday would fall in line with the other every other weekend that he is already exercising.
That is correct. And also, my client has to report to work. She just got a job within the last 10 days at 4:30 on Monday and Friday. So, but the plaintiff is aware of that and has been exercising his parenting time accordingly.
Good. Well, obviously communication is the key, and they've agreed in terms of who's going to pick up and who's going to drop off and all the exchanges, correct?
So far, the parenting time has been exercised in the marital home. But going forward, the parties do understand that Mr. Garcia can exercise his parenting time outside of the marital home. And if that does occur, then yes, they will have to coordinate transportation.
It's also our understanding if he exercises parenting time on an overnight basis, that he'll advise my client where he's taking the children.
Yes, he has no problem doing that as long as Ms. Garcia understands that she doesn't have the right to tell him no.
Well, perhaps it's not appropriate if he's staying at a girlfriend's home or and someone with a romantic interest. The children should not be exposed to that relationship at this point in time. So assuming it's an appropriate environment.
It is. That's not the situation at all. It's just that Ms. Garcia has retained the marital home. Mr. Garcia hasn't established a second residence yet, which is why that was part of this order. In the interim, he's been staying with family members.
Okay. Have the parties exchanged verified financial forms, affidavits?
Yes.
Okay. So if obviously if there's discovery necessary, the court believes that should be done between now and that August 1st mediation date. The court would like to just briefly identify the issues. And Mr. Clark and Ms. Nemec, there is real estate that needs to be divided. Is that correct?
Yes.
Yes, Your Honor.
Okay. And if in fact, unless one party is going to buy out the other's interests, the court suggests let's get that home in the market. Rather than wait till the fall. We have a 12-year marriage. So the court was to improve real property division, pension benefits. Mother has been pretty much a stay-at-home mother for most of the years. Is that correct, of marriage?
That is correct.
Does the father have any type of retirement benefits?
He does.
Okay, so I'll mark pension benefits. Spousal support may be an issue, maybe short-term rehabilitative. I'll mark that. What about, is there significant unsecured debt like credit card debt that needs to be divided?
There's debt. I don't think I would call it significant.
No, I wouldn't.
Okay, all right. Just court's curiosity, why is mom's name can be added to the Navy Federal if she cannot use it?
Mr. Clark informed us this morning that removal of her name from that credit card impacted her credit score. So we're going to add her back to attempt to remedy that so that she can attempt to build credit in anticipation of the parties separating financially.
Okay, that makes sense. All right, Ms. Nemec or Mr. Clark, do you wish to voir dire your respective clients this morning regarding this recommendation?
I don't think it's necessary, Your Honor.
Mr. Clark?
I would like to.
All right. All right, have both parties sworn.
Ms. Garcia, all morning we met with Mr. Walker and worked out any interim recommendation regarding the outstanding issues today.
Correct.
And did you hear and understand the issues and the resolutions that we've made?
Yes.
Are you willing to be bound by them?
Yes.
Do you have any questions regarding them?
No.
Nothing further, Judge.
Ms. Nemec, any questions of Ms. Garcia?
No, thank you.
Any questions for Mr. Garcia?
Zachariah, can you state your name for the record?
Zachariah Garcia.
You participated in discussions with Ms. Garcia and Mr. Walker from front of the court this morning, correct?
Yes, ma'am.
And you understand the recommendation that was the result of those discussions this morning?
Yes, ma'am.
You agree to the terms of that recommendation and to be bound by them?
Yes, ma'am.
Do you have any questions about the recommendation at all?
No, ma'am.
I have nothing further, Your Honor.
Thank you. Mr. Clark, do you have any questions of Mr. Garcia?
No.
Very well, court, would like to thank Mr. Walker for his assistance this morning in facilitating amicable temporary resolution, as well as, of course, attorneys Nemec and Clark. The court finds agreement between the best interest of minor children. The court will adopt the agreement. And with this recommendation of the parties mediating with Mr. Walker August 1st, the court will vacate the mediation scheduled for June 28th. So you can take it off your calendars.
Thank you.
Thank you, Your Honor.
And then we'll see you after the August 1st, 1/30th mediation with Mr. Walker, whatever time that may be. Right, that one matter will conclude this matter. The court will adopt the agreement. A copy will be mailed to council. For the record,
Thank
this
you,
matter is before the court on
Thank
the
you.
plaintiff's motion for custody, paternity time, and child support. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff, Kenneth Boyer. Mr. Boyer appears to be present. In addition, defendant Angela St. Peter appears to be present. And we have some other party, Mr. Shepard, that's present. In any event, the parties have conferred with Mr. Walker from the front of the court. The court did briefly confer with Mr. Walker because the court had the same question Mr. Walker had. Mr. Walker is recommending that the court dismiss this complaint. The reason that the defendant was married to a third party at the time the child was born. I think more than that, the court's question is, the court cannot establish paternity without a revocation of paternity. The court's informed that the defendant was married to another party that presumed bio dad at the time of the child's birth. Ms. St. Peter was divorced in Wayne County, but the judgment did not revoke paternity of this 7-year-old child. Is that correct, Ms. Nemec, your understanding?
My understanding, and the third party is Mr. Shepard, who is here today.
Okay.
There is a judgment of divorce that was entered in 2017. It does not address the minor child of this action, whose name is Braunlich. It only addresses the shared minor child of Ms. St. Peter and Mr. Shepard, who is Colton. It is silent as to that child. There is no child.
Did the parties not disclose to the court? Didn't the court ask if there were any other children born or adopted during the marriage, during the proofs?
I wasn't, I didn't represent anybody at the time of that filing. Ms. St. Peter was represented by a Mr. Roderick Green. And she is going to reach out to him. Your Honor, I would request that rather than dismiss this, if the court could give us some time, I really don't want to cause Mr. Boyer or Ms. St. Peter to go to additional expense. I'm wondering if Mr. Mr. Green could somehow amend the judgment of divorce in Wayne County to revoke that child's paternity, since all parties agree that the child's paternity is that of Mr. Boyer and Ms. St. Peter and not Mr. Shepard. All parties agree. And I think that that is borne out by the fact that that child was left out of the 2017 judgment of divorce between Ms. St. Peter and Mr. Shepard. So if we could potentially amend that judgment of divorce to revoke that paternity, perhaps we could proceed on this action. That said, I'm not familiar with Wayne County family courts any longer. I don't know how quickly that could happen. Ms. St. Peter is going to reach out to her prior counsel immediately and see if she can facilitate that. I will also provide her with another referral. I've actually started that process for another attorney who could assist her in Wayne County to attempt to get that accomplished so that we could proceed on this matter here in Monroe County.
Thank you. And the court is of the opinion that Ms. St. Peter would have to file a motion to revoke paternity in that divorce action rather than just simply submitting an amended judgment. I would think any Wayne County judge would want procedurally to have that motion filed before they amended the judgment. And with respect to this pending matter, as you know, Ms. Nemec, the court has time performance guidelines. They can't sit on this case forever. It's got to be adjudicated, and I'm not confident that this attorney is just going to drop everything and file a motion and get a quick hearing date. It could be 6 or 9 months. So at this point in time, the court will dismiss this without prejudice. If in fact the matter's taken care of in Wayne County, Ms. Nemec, and there's been DNA testing, in this case, the court can reopen the case upon the filing of a motion rather than have to file another filing fee. The court would be willing to reopen this upon filing of a motion.
To be clear, Your Honor, you would require then DNA testing?
Well, I guess if in fact, maybe it's not necessary, Ms. Nemec, if we have the presumed father and the alleged bio dad both provide testimony, and if all 3 parties testify that Mr. Shepard is not the biological father, but Mr. Boyer is in fact the biological father, that I think that would satisfy the court without having to incur the cost of DNA testing. So if Mr. Shepard can keep in touch with you, Mr. Shepard was married to Ms. St. Peter, correct?
Correct, and he is here today.
Okay, so Mr. Shepard, you got an obligation to support this child. You have a vested interest in assisting Ms. St. Peter, even with respect to attorney fees, if you want to resolve this issue of paternity. You both have the same interest in resolving this. So the court would suggest keeping contact with Ms. St. Peter, and so that Ms. Neiman can find you when necessary down the road. But at this point in time, the court's opinion is that the court cannot establish paternity until there's a revocation of paternity of this child. And I noticed from the pleadings that the defendant was married to another party at the time of the child's birth. So I perhaps shame on that attorney that didn't ask questions of his client before finalizing that divorce action. Anyway, anything further, Ms. Nemec?
I have nothing further. Thank you.
Mr. Boyd, do you have any questions?
Kenny, you're muted. There you go.
Oh, I'm good. Thank you.
All right. And Mr. Shepard, keep in contact with Ms. St. Peter so you can address the paternity of this child, this 7-year-old child. Then you've got the other issue, Ms. Nemec. You need to convince this court there's good cause. I mean, this is a 7-year-old child.
I understand, but the parties have always held this child out as theirs. Mr. Boyer has always been a part of this child's life. This child understands Mr. Boyer to be his father. Mr. Boyer does provide support and is an equal parent with Miss St. Peter.
Okay. And Mr. Shepard has no relationship with this child, is that correct?
That is correct.
Right. All right, that perhaps would allow the court to get around that 3-year time frame to revoke paternity up in Wayne County. So hopefully the judge up there will feel the same way. All right, that will conclude this matter. Matter is dismissed without prejudice.
Thank you, Your Honor.
Thank you.
Hey, everybody can log off.
I'm sorry, defendant's motion for to show cause. This hearing is being conducted via Zoom. Present is Attorney Dominic Camden, representing the moving party, the defendant Lowell Millette Jr. Mr. Millette Jr. appears to be present with Mr. Hampton in his office. In addition, Attorney David Stimson is present representing the plaintiff Christina Millette, and Ms. Millette appears to be present. Good afternoon, everyone.
Good afternoon, Your Honor.
The parties have conferred with Mr. Crabb this afternoon who has provided the court the following recommendation that any property that has been removed that belonged to the deceased son of the defendant shall be returned forthwith upon proof of the refuse bill and the proof of billing period. The plaintiff shall pay her portion of that bill. Plaintiff shall also reimburse the bill for DTE for the month of May 2023, amount of $129.55. Finally, the party shall share the cost of the repairs with plaintiff, be responsible for $500. That is the recommendation. Mr. Hampton, is this recommendation agree with your client this afternoon?
It is, Your Honor.
I'm sorry, Mr. Hampton, I did not capture your response.
It is, Your Honor. I apologize if the audio is not clear. It is.
Thank you. Thank you. And Mr. Stimson, is this recommendation good with your client this afternoon?
Your Honor, no, unfortunately, it's not. Only as a result of my lately being joined into this matter. Ms. Milletti just recently retained our office. I have not had an opportunity to review all the allegations. I have not seen any of the receipts or billing periods or bills or just anything to verify those aspects. So what we're asking for, Your Honor, is about 7 to 14 days to receive those receipts, those billing periods. We can then decide whether they're actually the right billing periods or they're actually bills there. And if they are, then my client is willing to be responsible for them. If they're not, then my client does not want to be responsible. And unfortunately, we just simply don't have that, and I've not had that opportunity. So we're just simply asking for the ability to file a proper response, which I'm again preparing today and would be able to drop some of that in to the mail to both opposing counsel as well as the court and retorting some of these allegations.
Well, the DT bill, May 2023, is that
well, for instance, that's one of the things, Your Honor. The debts were all settled throughout the course of the judgment of divorce. It's a holistic settlement done by Bill Godfroy, and that there was a continuation liability of her possessory after the fact that she needed to carry on the responsibility of paying for bills after December of 2023. But this is a claim of some bill that they were both living together for part of it. She had exclusive use for part of it. It was part of the debts associated with the settlement. We do not believe it should even be able to be brought forward. So I don't have proof that it was paid by Mr. Milletti. I don't have proof that it wasn't paid by Ms. Milletti. There was just a billing statement that's been provided via Zoom today.
Okay.
Same with the garbage. They don't even have the bill for that today. They just have a written statement by Mr. Milletti saying these are owed.
All right. Do you have those documents, Mr. Hampton, that you can forward to Mr. Simpson?
Judge, the recommendation I think you have in front of you basically says I have to forward those records, and so we're willing to accept that as a precursor to reimbursement. We do have the DTE bill, Judge. I do believe I also have the trash bill. But in reviewing my file, I believe that's actually in my prejudgment file, so that may be downstairs in storage. I looked for it when it became relevant and could not find it, but I do believe I have it.
Okay. What about these repairs? What are the repairs? Party shall share I understand the refuse bill, the DTE, the billing period, the cost. Mr. Tipton, you want proof of that? No problem. What about the cost of repairs?
I don't.
We're paying $500. What, do you have an issue with that as well?
We don't know what any of these repairs were. The house was in good order. There's been allegations that there was some sticky residue or something might have been affixed at a kitchen and that he removed it and it damaged the drywall and that she should then pay for the drywall. And so we don't know what any of the details of it are other than a hand typed kind of, you owe me $40 for painting the kitchen. I don't know if that's fair, if that's reasonable, what they're really alleging are. So we do have a problem with all of that aspect. My client is willing for a holistic settlement to simply just pay $500 to be done with it. She's already paid the DTE bill. We provided proof of that today, amount of $305.
Okay. What about the personal property that belonged to Mr. Molet's deceased son?
We left.
Client acknowledge with some of that possession of some of those items?
She does not have possession of items. That is her statement. She's indicated that he had the opportunity in December to come retrieve those items, which was arranged in the judgment. He did not. He was required to submit all disputes about items that are personal property items to Mr. Godfrey for arbitration by April 1. He did not. So we do not have any of those items. He's making allegations that we do. She said they were in the house when she left.
In the house?
Yeah, that's her statement. Is that correct, Miss?
Yes, that's correct.
The defendant was awarded the home, Mr. Hamden, but he said none of those items were in the home?
Correct, Judge. And there was a delay in my client getting to do a walkthrough, and I'm not going to get into the details of it, but there was a delay with my client's ability to do the walkthrough. But every photograph of my client's deceased son that showed a clear view of his face and his body is missing. They were last in the home. Every photograph of them is missing.
Well, I guess we could take some sworn testimony from the plaintiff if you want, in terms of what happened with that. Can we address that issue today? I mean, if in fact she didn't touch it, left it there, I'm not sure the court can order to return something that she doesn't exist.
Well, it does exist, Your Honor. My client would testify that it existed and it was last in her possession. Then when he took over possession of the home, every photograph was missing. What might make sense, Your Honor, is for the court to grant Mr. Stimpson's set over for a week or 14 days. I will get him the DTE bill. I will get him the trash bill. He can have a conversation with his client with regard to the repairs, and then perhaps she can go back and double check everything. And then if she's willing to turn it over, if she finds something, my client may be willing to let this ride and let it go.
Okay, sounds like a game plan.
He believes the photographs are there, and he believes that she took them, whether it was on accident or on purpose.
Okay. Mr. Simpson, maybe your client by accident, maybe she can look through her things. Obviously, it's important to Mr. Molet, so I'm just suggesting she go through maybe some boxes that she retrieved in the house, just to make sure that didn't inadvertently get picked up with other matters. Obviously, it's important to Mr. Molet. So, Ms. Christina, the court would encourage you. It's the right thing to do. So go through any boxes and really see if you can find those, because it means a lot to Mr. Molet. Okay. So you think what, 2 or 3 weeks?
Yeah, that's probably sufficient, Judge.
Okay. Right. The court's going to print off a copy of recommendation just for the court's future reference, but we will not enter it at this time. We'll simply adjourn the matter for a couple of weeks so that the parties can exchange those documents.
I have Tuesday, July 2nd at 9 a.m. or 9:30 or 1:30 or 2.
Your Honor, I will be out of the state of Michigan the first week of July.
I have then Tuesday, July 9th at 1:30.
I can do that.
As can I, Your Honor.
I'm sorry, that work with you? That will work with your schedule, Mr. Hamden? All right.
Yes,
right,
Judge.
Mr. Pratt, I printed off your recommendation for today, just for the court's future information, and have some bearing what we're talking about. But the court will, this time, will adjourn this matter to July 9th, 1:30, per agreement of the parties, so that they can engage in some brief discovery.
Yes, sir. I'll get that uploaded in your queue.
Is it
Certainly,
possible, Your Honor?
a personal property is a car amplifier. I mean, how big is that amplifier? I mean, that's something Miss Mollett would know if she had. The photographs, the CDs that may have gotten mixed up with other things in the box, but how big is the car amplifier?
It's good size, Your Honor. My time, how big would you say?
It's like probably this size, this thick, this wide.
Maybe 12 inches wide, maybe 18 inches long.
Yeah. 3 to 4 inches thick.
3 to 4 inches thick, Your Honor.
All right.
This is like an amplifier you would do at a car audio system?
Yes.
Okay. Well, hopefully, Mr. Stempson, you can discuss those items with Ms. Mollett, and she perhaps can refresh her memory when we come back. So we'll put this over to July 9th at 1:30.
Thank you.
Thank you, Judge.
Judge, that recommendation is in your queue to do the adjournment.
Thank you.
Thank you.
For the record, this matter is before the court for the purpose of reviewing the defendant father's parenting time. This hearing is being conducted via Zoom. Is Joshua Rodriguez present?
Yes, sir.
You speak up, Mr. Rodriguez, where you have a very faint response.
Yes, sir. I'm here.
Okay, yeah, speak louder and right into your device, please, so we can pick you up. All right, Mr. Rodriguez is appearing by audio. Is Rose Miles, formerly known as James, is she present?
Yes, I'm here.
Okay. All right, parties are both present in audio. The parties have met with Mr. Walker from the front of the court. Mr. Walker has provided the court with a fine recommendation that parenting time for defendant father shall continue as previously ordered. I mean, which is father shall have parenting time every other Saturday and Sunday from 11 a.m. to 5 p.m. The exchange should be at the Meyer gas station in Monroe at 11 a.m. and the Blissville police station at 5 p.m. That is a recommendation. Miss James, do you understand the recommendation?
Yes, I do.
You're now known as Miles, is that correct?
Yes, it's now Miles.
Okay. Do you have any objection to the court adopting this recommendation?
No, I do not.
All right, Mr. Rodriguez, do you understand the recommendation?
Yes, I do.
Do you have any objection to the court adopting this recommendation?
Yes, I do.
Okay, well, go ahead. What's your objection?
I really can't do anything with him when I get him for a few hours a day, every other weekend. So it just makes more sense for me to be able to do something with him instead of going back and forth and then me not really being able to spend any time with him. So it just makes a lot more sense just to keep him overnight so we can actually do something, especially the summer being here now. And instead of going back and forth and he's in the car most of the weekend, that don't make any sense to me.
How long a drive is it from Monroe to Blissfield? 30 minutes?
45 minutes.
45 minutes? The child is 5 years old, correct? Your child?
Yes, sir.
The court made a note from the last time you were here back on May 8th, because you were concerned at that time about the drive time for the 5-year-old child. Miss James, are you opposed to Dad, if the court perhaps consider something like alternating weekends, Saturday at 11 to Sunday at 5?
I mean, I'm honest.
Dad would have some overnight.
I'm not trying to be rude or anything, but I sat here and I added it up the other day, and I'm sitting in front of it. The amount of times that he's canceled visits since January 1st of 2023, he has totaled 152.5 hours with Dominic. I have offered him extra time. He has refused. I've offered to include him in his t-ball games. He's refused. I've offered to invite him to birthday parties. He's refused. He does not communicate what he does with me when he has Dominic. And 9 times out of 10, Dominic does not want to go with him. He tells me he hates going with him, that Josh is mean to him, that Josh hits him, that his siblings over there are mean to him. I just really don't feel comfortable with my son staying the night, especially since he can't be consistent and form a relationship with him to make him want to go to his house.
Okay, well, it's a valid point if he's been inconsistent, but do you think he's capable of taking care of him overnight, overnight for Saturdays?
I mean, I honestly don't know. And I don't understand why he's so pressed for my son to sleep at his house. He's literally had over a year to buy him his own bed over there. He don't even have his own bed. He says he can share a bed with somebody. That's not cool because he has his own bed at home.
He should have his own bed at 5 years old. Is that correct, Mr. Rodriguez? Dominic would not have his own bed at your home?
There is a bed that he's able to use. My stepson that lives with me goes with his dad. On the weekends, I get Dominic. Dominic can stay in that room. That room can be his the whole weekend. There's no problem with him staying there by himself, sleeping in that bed by himself. No problem. It's a twin-size bed, a kid's bed.
So your stepson is only at your home every other weekend, is that correct?
No, my stepson lives with me, but he goes with his dad every other weekend, the weekends that I get Dominic.
Okay, so when does he go with his dad? Like what time on Saturday and when does he come back on Sunday?
He goes with his dad 9 o'clock Saturday morning, comes back 7, 8 o'clock Sunday night. So that clears all the time I have with Dominic.
All right. So Dominic would have his own bed then, correct?
Yes, sir.
Okay, and what weekends, for example, like this coming weekend, is your stepson with you or is he with his dad?
He's with his dad. It's my weekend to get Dominic.
So your stepson would not be in your home this weekend, correct?
No, sir.
Okay. Do you work on Saturdays or Sundays?
I work on Saturdays, but I don't have Dominic. The other time my job understands that I get Dominic on Saturdays every other weekend, so I don't work those. Another high-low driver covers my shift.
So if the court gave you overnight parenting time, like say Saturday at 11 till Sunday at 5, you would be there during those hours to spend time with Dominic, is that correct?
All day, all night, yes, sir.
All right. Have you ever had Dominic overnight in the past?
No, Dominic hasn't stayed the night anywhere ever before, so I know this would be a very huge adjustment for him, especially since he's already resistant on going with him.
I'm sorry, what was the last comment?
I said it. I think it would be a huge adjustment for him, especially since he's already resistant going 2 days in a row to see him.
Well, you don't know why he's resistant. You have to encourage it, Mom. You have to
I
encourage
do.
that. Maybe he's resistant to the drive time, sitting in a car so much back and forth. But I think we should give it a try. Yes, the 5-year-old is pretty resilient. Yes, it's an adjustment, but he can adjust to that. What the court is suggesting, well, we'll give it a try and come back in maybe 45 days.
Okay, well, can I ask 2 things if we're doing the overnights?
Go ahead. I'm trying to start some discussion. I think we should start that.
Okay, so if the overnights is granted, can we have pickup and drop off at my house? And then can I be allowed a 2 to 5 minute FaceTime or phone call with him before bed around like 8 o'clock?
Absolutely. The FaceTime is certainly reasonable. But again,
he already picks his other son up in Monroe, not that far from me. So I don't think that picking and dropping up off at my house would be that big of a deal.
Oh, is that correct, Mr. Rodriguez? You pick up your son in Monroe?
Yeah, I have another son that I also get on the weekends. I get Dominic.
Different weekends?
No, the same weekend.
Okay, so why couldn't you pick up and drop off Dominic in Monroe rather than Blissfield?
I don't see a problem with it.
I'm sorry, who lives in Blissfield?
I do.
Joshua.
Okay, Josh lives in Blissfield. Okay, but Mr. Rodriguez, if you are coming to Monroe to pick up your other son, couldn't you also pick up Dominic?
Yeah, I don't have a problem picking them up and then dropping them off. I just have a problem picking them up, dropping them off, picking them up, and then dropping them off again. That's the problem I have.
All right, but if the court gave you alternating weekends, what I'm suggesting, alternating weekends, Saturday at 11, Sunday at 5, can you pick them up in Monroe at 11 o'clock on Saturday and drop them off Sunday at 5 o'clock?
Well, actually, I drop off my son at 4 o'clock in Monroe. That's why I have
Okay.
Dominic picked up at 5. So,
Okay,
if
well,
you want to
obviously,
change
we're
to 4, I
dropping
can
off.
drop them off.
You're gonna drop them off at the same time, so let's say, what if you pick them up, say 10 o'clock on Saturday morning, dropped them off at 4 o'clock on Sunday?
That'll work. Can we still do it at Myers gas station though? Pick up and drop off?
Meyer gas station is literally less than a mile from my house. I don't understand what the problem is of just picking them up at the house.
That's what you chose. That's pick up and drop off. You chose in Monroe was Myers, so I'm just trying to stick with that. That's what you chose.
Well, sometimes if there's content, we don't want there to be issues between the parents. Sometimes you need to exchange at a neutral location. If there's gonna be issues, we don't want issues at mom's house.
There's never been an issue at my
so
house.
mine-
I've literally invited him in my house before to see Dominic and he refused to come in. There's never been an
Right.
issue. I just figured it
Right,
would be
Mr.
easier since he's already out driving and I'm already at home with my kids. I don't know why he couldn't just come pick him up from here. It might be easier to pick him up from the house so I can like walk him out to the car or something. I don't know.
Rodriguez, what about that? Why can't you pick up Dominic from mom's house?
I guess I can if I have to.
All right.
That's fine.
All right, so let's give us a try. We'll come back. Mr. Walker, if you are still there, can you be kind enough? The court's going to modify parenting time, and we'll give it a try. There's a lot of running for this child, back and forth. So the court is going to order that father have a parenting time alternating weekends, Saturday at 10 a.m. to Sunday at 4 p.m. Dad will pick up and drop off the child at mom's house in Monroe. And that dad's weekend parent time will start this weekend, which is June 15th. So let Dominic know, Mom, that Dad is all excited about picking him up. And Mr. Rodriguez Court suggests plan something fun for Dominic. Take him to a park, take him to a water park, maybe in Dundee or something. Do something unique, something fun. Take him to the zoo that he will remember that. Rather than just hanging out at your house, plan something. That's what the court would suggest and encourage. So that he'll look forward to coming back.
I'm already planning camping. It's hard to go camping with my family if I got to get Dominic on the weekend. That's my only weekend now, so it's easier for me to get him overnight. He can go camping with us.
Well, but this is time I think you want to focus in on Dominic. I understand you've got other children, you've got a girlfriend or a wife or whatever, but you really got to give some special attention to Dominic this weekend. So your parenting time will start this Saturday, June 15th. You'll pick up Dominic from mom's house at 10 o'clock in the morning. You'll drop him off to mom's house Sunday at 4 p.m. And that'll be alternating weekends. So it'll be the weekend of the 15th and the 29th of June. And we're going to give you a date to come back for review. You got to be consistent. And also, so one other thing, Mr. Walker, Mom shall have a right to have video contact with Dominic. What's a good time? 7 o'clock in the evening? When does Dominic go to bed, Miss Rose?
He usually starts like getting ready for bed around 8 o'clock.
Okay, so what do you think, 8 o'clock?
Yeah, 8 works for me if it works for him.
Okay. Mr. Rodriguez, would that work 8 o'clock? You would make sure Dominic was available to talk with his mom briefly on the phone just to say hello and how he's doing.
Yes, that's fine. But he's not always going to be in bed because we're out doing something and driving back.
I understand.
It'd be 8 o'clock. It'll be 8 o'clock.
You're just going to tell him, you're going to make sure he's available at 8 o'clock. Who's going to initiate the phone call? Mom, will you initiate to Dad, or do you want Dad to initiate the phone call to you and give the phone to Dominic?
He said he doesn't know if he's gonna be driving, so it'd probably be best for him to call when they're like settled down and stuff.
Okay. So, Mr. Rodriguez, do you have the phone number for Rose?
Yeah.
Okay, so the court's gonna order that on Saturday night that you initiate phone contact between Dominic and his mother, 8 o'clock and 8 p.m. every Saturday night, okay?
Okay, I have an iPhone. I don't know what kind of phone she has, so I don't know how I'm gonna FaceTime her.
We could do either Zoom or Google Meet, or if that doesn't work, a phone call, just so I can talk to him.
Okay, if you can to FaceTime, I think all iPhones you can FaceTime, but if you don't know how to do it, then at least the phone call.
Okay.
So that'll be part of the order.
8 o'clock.
Yep, 8 o'clock every Saturday night. Dominic is with you. And it'll give Dominic a comfort zone. You want Dominic to be comfortable in your house, Mr. Rodriguez, and the court wants nothing more than that. So let's give us a try, and we'll come back. The court's suggesting, what if we come back? Do you want to come back at the end of July, or the 1st of August? Let's let this. Let's give this a try for at least a month and a half.
Okay. Another thing, I work, so can it be after 2 o'clock? The court hearing.
I'm sorry, Mr. Rodriguez, you said you're working?
I work, so it has to be after 2 because I don't get out of work till 2.
Okay. You get out of work at 2 o'clock?
Yes, sir. Then I got to drive home.
Okay, we have 3 o'clock, 31st. How about July 31st at 3 o'clock?
Yes, sir. That works.
All right. All right. So we'll put in this order that the parties will appear back for his court to review. If it's not working, Miss James, I'm sorry, Miss James or Miss Miles,
Okay.
Mr. Rodriguez, if it's not working, we'll adjust it at that time. Let's give it a try between now and July 31st. So it can zoom in at 3 o'clock on July 31st, and we will evaluate and review Dad's parenting time.
Okay.
All right. Let's give it a try. Do you have any questions, Miss Miles?
No, I don't believe so.
Okay, I appreciate you being open-minded, and you got to encourage it. Tell them that Dad's looking forward. You're gonna have fun with Dad this weekend.
I know, I try to too. Like, even when he's like resistant, I'll text Josh and I'll be like, hey, Dominic's saying he doesn't want to go. Do you want to try calling him real quick and, try talking him into it, or tell him you miss him, or tell him you were excited to see him or something. He's just kind of like, I'm already on my way. I'll see you when I see you, kind of thing. So I think that's kind of why too. So I don't know. Hopefully it'll be okay.
Okay, encourage it, build it up for Dominic, and tell Dominic you'll be talking to him at 8 o'clock every Saturday evening that he's with Dad. Mr. Rodriguez, do you have any questions?
No, sir.
Okay, so you're gonna pick up Dominic this Saturday at 10 o'clock and return him at Mom's house at 4 o'clock. So the pickup drops off be at Mom's house. All right, so with that, give it a try. We'll see you both on July 31st at 3 o'clock.
Okay, thank you.
Thank you.
Ms. Patrick has met with the parties. Ms. Patrick is recommending that the court, in order that defendant files parenting time will continue as previously ordered, namely alternating weekends, Saturday at 10 a.m. until Sunday at 4 p.m. And all other prior orders remain in full force and effect. That is a recommendation. Miss James, I'm sorry, Miss Miles, formerly known as James, do you have any objection to this recommendation?
I mean, I'd rather it go back to every Sunday, but she kind of basically told me that this is like standard and I have to call CPS if I'm worried about my son's safety. So.
Well, do you both agree to every Sunday?
No, he doesn't. Sir. I told him that I would drop him off and pick him up too, but he's still saying no. So.
All right. And the prior order, of course, there's a mother shall have a video call with the child every day at Saturday at 8 o'clock during father's parenting time. Has that been occurring?
No, I've only gotten one video call.
You didn't get two?
All right. So Mr. Rodriguez, do you understand the recommendation?
Yes, sir.
Objection to the court adopting this recommendation. Continue your parenting time, alternating weekends, Saturday at 10 to Sunday at 4.
I have no objection.
What about the video calls? Why is the child not having video calls with the mom at 8 o'clock on Saturdays?
The first weekend I had him overnight, he fell asleep early. So I took a picture of him. He called her in the morning. The weekend after that, my phone is messed up. The video is messed up. So I called her, and then the weekend after that, I got the video call, and then I didn't get him last weekend. She didn't let me get him last weekend.
All right, did you receive those phone calls, Miss Miles?
I did receive the phone call, but like he said, his phone is messed up. So the whole time I'm trying to talk to him on the phone, it's basically me saying my son's name, like, can you hear me? And him saying, Mom, can you hear me? So it's kind of
Mr.
hard.
Rodriguez, you need to get another phone or borrow someone's phone. The court said if 8 o'clock is too late, maybe the child's sleeping, so let's move it. How about do it at 6 o'clock on Saturdays? Will that work better for everyone?
That's fine. Yeah, that's
Miss
fine.
Miles?
Yeah, the time isn't really, it doesn't really matter. I'll answer the phone.
Hold on, the child's 5 years old. Sometimes 5 years old they fall asleep at 8 o'clock. So I don't want you to complain saying you're not getting the phone calls because he's sleeping. So I'm just saying, why don't we move it up?
Yeah, that's fine with me. Josh is the one who picked the 8 o'clock time. He was the one saying that 8 o'clock was too early. So I just
don't want there to be any issues about the child sleeping, and then you're complaining that you're not being able to talk with your son. So, Ms. Patrick, we just simply, everything remaining in full force and effect, other than the phone calls, father shall initiate phone calls to mother every Saturday at 6 p.m. So, Mr. Rodriguez, make sure you have a good phone.
Yes, sir.
If you have to, borrow a phone.
Yes, sir.
You understand that, Mr. Rodriguez? It's important that your son talk with his mother at 6 o'clock on Saturdays.
Okay.
All right, and if there's the issue, the exchanges will still occur at mom's home. The father will provide all transportation. If there's issues, Miss James, Miss Miles, you can always call Protective Services. Obviously, hopefully, Mr. Rodriguez will keep the child safe. Mr. Rodriguez, does the child have his own bed?
Yes, sir.
Okay, and who else lives in your house?
Who lives in my house is me, my fiance, and my 2 boys.
Okay. Or does Dominic have his own bed?
Yes, he does.
Oh, okay, just want to make sure that's appropriate environment for Dominic to spend the nights. All right, the court will adopt the recommendation of Ms. Patrick. The parenting time will continue. Father shall do all transportation, pick up drop-offs at the mother's home. And the only thing the court's going to change is that the father shall initiate video calls at 6 p.m. on Saturdays rather than 8 p.m. So we don't have any problem with the child sleeping, okay?
Yes, sir. But real fast, is there any way I can pick him up and drop him off at Myers gas station? It's like a mile down the road from his mom's house. I'm just not comfortable going to her house. And anytime I go to get him, he's like not fully awake. So I'd rather have him awake, and that way we don't have the argument of him not wanting to go and stuff like that. It's just to wake him up. Or actually, I can drop him off.
He's not awake at 10 in the morning?
Yes, he's awake.
I don't know.
He's talking about the last time he came to pick him up. Dominic didn't want to go, and he was hiding behind the chair, and I was trying to coerce him out to go with him. And I even told Josh, I said, can you please just come inside and tell him you missed him, tell him that you want him to go with you, something. And all he said was, I don't have time for this. I have to go get Lorenzo now. And so then Dominic started like crawling out, scared out from behind the chair, but that was it. He comes home and tells me that Josh is mean to him all the time, and that he's scared of him. So that's why he didn't want to go.
All right. Mr. Rodriguez is asking that the exchange take place in the Meyer store. What's your position on that, Ms. Miles?
I don't understand why he can't just come to my house. Myers gas station is literally less than a mile. It doesn't make sense if he's already out picking up his other son. So I don't understand why he can't just come to the house like he's been.
Obviously, I'm sure your Dominic would want to stay at mom's home till you're ready to pick him up, Mr. Rodriguez. So the court's going to keep it. All exchanges shall pick up drop-offs at mom's home. Okay.
Okay. Also, can she make sure that he is ready to walk out of the door when I get there?
He
I
is
don't-
always
A
ready.
5-year-old child, hold on, Mr. Rodriguez, you have a 5-year-old child, and obviously if he's hiding, if he's not real comfortable going to your home, it's sort of hard to have him ready and standing there waiting for you. And you got to make things real good for Dominic that he's looking forward to seeing his dad. So mom's going to do her best, okay?
Okay.
All right, with that,
Thank you.
again, the only change what we'll do is the video chat shall occur at 6 o'clock on Saturdays. If you can add that, Ms. Patrick, thank you. All right, to Mr. Rodriguez, Ms. Miles, you can both zoom out. Have a good rest of the afternoon.
Thank you.
Well, Josh was pretty sharp on the case we had today, unusual one. I had to really read the pleadings carefully. It was a DP, newly filed DP case. And of course, the mother was divorced in Wayne County, but never told the Wayne County judge, we had another child. And I just said, and then I had the same questions Josh had. I'm glad he was able to catch that. He got some pretty smart mediators down there, because how can you establish paternity if you've never revoked paternity?
That's a good question. Thank you, Your Honor.
So I'm glad Josh, looks at those, knows the right questions to ask, because likewise, I thought, this does not make sense.
Right. Let me bring that one in for you, Sarah.
Okay.
So we appreciate all of your efforts, you and Stephanie and Mr. Walker every day.
Thank you, Your Honor. That's good to hear, especially today. It's been a little crazy down here.
Emily Connors.
Oh, yeah, no, that should be in proper optics, Your Honor.
Thank you.
She did indicate when we were in the breakout room, though, she was having some medical issues. So I'm wondering if that's what happened.
Yeah, she hasn't come back. Want me to take Stephanie's?
Yeah, maybe we should take steps first and see if she is able to come back in.
Okay.
Okay, we'll do that.
Thank you.
Court is now in session, top of page 4, Chanel Olson versus Michael Levanis.
For the record, this matter is before the court as a result of this court entering an ex parte order on April 18th, 2024, awarding defendant father temporary possession of the 7 6-year-old children of the parties and suspending plaintiff mother's parenting time, and further requiring that the children continue in school in the Tramp Academy in Monroe. The order ex parte order also scheduled matter for hearing today to review. Miss Olson was in a coma, unable to provide for the children. When the court entered the order back on April 18th, the court's informed she's now residing in nursing home, but she has not appeared this morning and not physically capable of appearing. However, for this hearing is being conducted via Zoom. Present is attorney Chantel Neff, representing the defendant father, Michael Levanos. Mr. Levanos is present with Miss Neff. In addition, attorney Maria Zgorski is present representing the Sarah Olson, who is the grandmother of plaintiff mother Chanel Olson.
Your Honor.
Good afternoon, everyone.
Good afternoon. My client is Chanel's mother. She's the grandmother of the minor children.
Yes, she's a court appointed. She was an appointed guardian by the probate court of plaintiff mother Chanel and grandmother of the 2 children. Correct. Yep.
That's right.
All right. Perhaps I misspoke. Yeah, so the parties have met with Mr. Pratt from the front of the court. Mr. Pratt provided the following recommendation that the children shall remain in possession of the father, grandmother. Sarah Olson shall have the maternal grandmother. Sarah Olson shall have parenting time every Saturday from 10 a.m. to 6 p.m. Presumably, I don't know if she's going to take the children to see their mother. I don't know if that is appropriate for a 7 and 6-year-old, Ms. Zgorski. Is Miss Sarah Olson, is she present in your office, Ms. Zgorski?
She is, Judge, and it's her opinion that we should defer to the children's therapist. I understand that the children are seeing Asia at Great Lakes, and I was asking sister counsel for more identifying information, including Asia's last name, so that my client could defer to the therapist's thoughts about that.
Okay, that's appropriate. It's further recommended the children remain in their current school, which is Tramp Academy. There should be no physical discipline of the minor children. And finally, the guardian will discuss parenting time, the children's parenting time with the mother with the children's counselor. Ms. Neff, is this recommendation agree with your client this afternoon?
No, Your Honor.
Okay, what does he object to?
My client does not want to have the maternal grandmother having essentially parenting time from 10 a.m. to 6 p.m. every Saturday. He doesn't feel also that it's in the children's best interest to see their mother in her current.
Hold on. Again, the recommendation is that the guardian will confer with the children's counselor before introducing the children to their mother.
Mhm.
And I presume your client is also confer with the counselor to discuss that. And so that your client is aware whether or not the children, your client should be able to determine what the recommendation of the counselor is.
Yes.
Yes, the guardian should not be, if it's contrary, she should be acting in accordance with the, maybe we need to reword this, Ms. Sikorsky, so that the guardian will not take the children to see their mother unless I'm trying to think how we can word this without the counselor's blessing, without the counselor suggesting it's appropriate.
That's understood. I mean, I don't mind how it's worded. My client would never do anything to cause further harm or trauma to these children. She only wants what's best for them, and she would not take the children to see their mother unless their therapist signed off on it. Okay, so how do you suggest we reword this? This just says that the guardian will discuss the issue with the children's counselor. It doesn't. I don't mind saying she'll defer to the children's counselor regarding when it is appropriate for the children to see their mom. Okay, Ms. Loprato, are you still there?
Yes, Your Honor.
Can we reword that to the last sentence about
Absolutely.
The guardian will defer to the children's counselor as to the appropriateness and timing of the children visiting with having contact with their mother. We need that therapist's last name. Ms. Neff hasn't yet provided it. All right. Do we know the name of the counselor?
Yeah, her name is Asia Stevenson.
Thank you.
Also, Your Honor, I don't know if I may have missed this, but my client doesn't agree to the maternal grandmother having the children every Saturday from 10 to 6.
Okay. Does the grandmother have a relationship with the children?
I mean, she had a relationship with the children.
Okay. So what is it? Too long of a period of time? Too long of a day? Is that what you're suggesting?
Every Saturday is too much. And I don't believe that they didn't file a grandparenting time petition. And I don't believe that there's anything under Michigan law that that would force or that would allow a grandparent or a guardian to have parenting time with the minor children.
Well, sometimes dad needs a little break. Sometimes we'll give him a little break when someone else that he trusts is watching the two children. But I guess it's a valid point. Ms. Sikorsky, what's the response to grandmother's not filed a petition for grandparenting time? And that's essentially what you're seeking here.
Well, no, yes and no. I mean, I can file a petition for grandparenting time. I don't think I have to. My client is now a real party in interest because she is the guardian of plaintiff mother, and she seeks to facilitate the relationship between these children and their half-sister. It has to be remembered that these children spent, as I've pleaded, half of their time with their mother and their half-sister, and very often that time was spent with my client. My client went to parent-teacher conferences. My client went to field days. My client took these children to the doctor while their mother was at work. My client was very, very active in their lives, and all we know, because the defendant has allowed absolutely no contact, all we know is that these two little girls have no idea what happened to their mom, had no idea what happened to their other sister, and have no idea where their grandmother went.
That's inaccurate. The guardian actually sent a bunch of inappropriate messages to my client. And my client just wants to take it very slowly, reintroducing them. According to the girls, when they're with their grandmother, she would spank them and she would yell at them. So my client has concerns about that. Also, my client believes that the guardian knew that Chanel had a drug problem and that she was in rehab and failed to inform him of this. And more so just tried to cover it up. So he has concerns about them being with her for those reasons. And her half sister recently tried to commit. And it's just, my client just wants to keep the girls safe and do what's in their best interests. They've gone through a lot of trauma with their mom trying to kill her, and they just want to get into like a routine and then slowly, reintroduce and get back a relationship with the grandparent and the half sister, but do it slowly over time.
All right, Mr. Gorski?
Yeah, similarly, my client has some really significant concerns about Dad's house. Her ward, the children's mother, was the victim of his domestic violence. I attached the most recent case from late 2023, but Your Honor signed a PPO, a very extensive PPO. It's case number 19-141978-PP. You issued that against Mr. Levanos because of his violence toward my client's daughter, the plaintiff in this case. I think it would be in the children's best interest to see their grandmother and see their half-sister and have some semblance of normalcy with having these people in their lives. A Saturday is not going to be that inconvenient one time a week to see the people that they used to see 3 and 4 and 5 times a week.
And also, I'd just like to point out, I don't see any police report here, and this case was dismissed. So I believe that you're referring to. My client doesn't have a violent home. He has a very safe and good home for the children. They don't allow hitting or anything else at the house. And the girls are doing really well.
With whom does Mr. Levanos reside?
He resides with his fiance and the 2 minor children.
Okay, what's the date of this planned marriage?
This year, October 23rd.
Okay. And how old are the children? The fiance's children?
She doesn't have any children.
Oh, I'm sorry. Oh, the 7 and 6-year-old of Mr. Levanos and Miss Olson you're referring to. And the 7 and 6-year-olds, are they boys or girls?
They're both girls.
Okay. Do they share a bedroom then? They got their own bedroom?
They do.
They do have their own bedroom.
Okay. And Miss Zagorski, with whom does the guardian reside? How old is is it just her and the stepdaughter? Or half sister of these children?
Yes, Judge. She resides here in the city, and the children's half sister is 13, McKenna.
Okay, and obviously before the mother was hospitalized, what was the parenting time arrangement?
Judge, Dad would have the children on a 2-week rotating basis, according to my client. Week 1 would be Thursday to Sunday, and week 2 would be Thursday to Monday, because Mom worked weekends. So Mom would have Sunday to Thursday or Monday to Thursday each week, and Dad would have the weekends.
Can I just make one comment? My client is under the belief that Sarah Olson has 2 roommates that reside with her. Is that accurate?
No, it is not.
So it sounds like these 2 children, the 7 and 6-year-old girls, spent considerable time with the guardian, Sarah Olson. So it's not like there was not any regular contact. So at this point, Ms. Nafma-Skorsky, the court will adopt the recommendation of Ms. LaPrade. The guardian is not a stranger to these girls. So grandma should have parenting time every Saturday at 10 a.m. to 6 p.m. Do we start that this Saturday or the following Saturday?
The sooner the better for my client, Judge.
Ms. Neff, did Mr. Levanos have any plans this Saturday with the girls? Specific plans?
Yes, they're now that they're out of school, they're enrolled in summer camp. And they actually have tumbling every Saturday morning.
Okay. What time?
from 10 to 11.
Okay,
Also, Your Honor, the recommendation from, the friend of the court, would not allow the girls to change their schools. We believe it's in the best interest for the children to change their schools.
the court does not agree with that. Right now, the children need consistency, continuity. And we're almost end of the school year, correct? Isn't school didn't just finish?
Yeah, the school is over. We were talking about, in the fall.
Okay, we can address that during the summer. Let's see how things go. See how, whether mom makes any progress with her condition. I don't know what the prognosis is in terms of her recovery from this coma. Is she still in a coma? Is she able to feed herself?
No, Judge, she is conscious. She's smiling. She's crying. She's improving daily. My client was advised that the first 3 months are critical, and there's been a lot of progression. And so we're hoping, she's in physical therapy. She can hold her head up. You know, they're trying to remove her trach. So we're making real progress here.
Okay. So the girls have tumbling every Saturday, Mr. Lavanos?
Yeah, correct.
10 o'clock?
My client can pick them up from tumbling if that makes things easier.
What about that? We change it to 11 o'clock and guardian can pick up the girls from tumbling?
Do you want to do that? Or maybe a day after school?
You're done with school.
Your Honor, maybe Sunday would be a better day.
We're fine with Sundays. We can do Sundays 10 to 6.
Ms. Neff, would Sunday be better than Saturday with the girls' activities on Saturday?
They have Girl Scouts on Sundays.
They have Girl Scouts on Sundays.
What time? Is it every Sunday?
It's every other Sunday from 2 to 3.
Okay, well, the guardian could take them to do that program. So we'll change it. It would be every Sunday then, 10 to 6. Obviously, and you need to tell the guardian they've got this other activity on Sundays and where it's at. And obviously, Ms. Skorsky and Ms. Olson, I presume you can take the children to that activity on Sundays?
Yes, she can.
Okay, and that's, where is it at? Is it at school? Is it at?
It is in Southgate.
Southgate?
Yeah, Your Honor, would you consider allowing every other Sunday so they can take them to Girl Scouts and she can have her Sunday?
Right.
But Judge, I think you know, the recommendation was weekly contact. We're accommodating Dad's schedule. He doesn't want it on Saturday. We'll do it on Sunday. My client can take the girls to Girl Scouts. It's not an issue. She has no problem doing that. It would be nice for them to have their grandmother at Girl Scouts.
Okay. I would agree. So the mother's parenting, the guardianship parenting time every Sunday from 10 to 6.
Nancy and I are like very involved.
They'll start this Sunday, which is the 16th of June. I'm sorry, that's Father's Day. That's Father's Day, right?
Yes.
All right, so we'll start I'm sorry?
We can take Saturday this weekend.
We'll do it Sunday, starting June 23rd. Let's keep things simple. Rather than alternating Saturdays and Sundays. So the guardian shall have parenting time on Sundays, beginning June 23rd, 2024, 10 a.m. to 6 p.m. The guardian will transport the children to their Girl Scouts activity on the Sunday afternoons in Southgate. Mr. Lavanos, you have to provide that information in terms of where it's at. Is it a den mother's house or Girl Scout leader's house? Is that where it's at?
It's at a church.
It's at a church. Okay, so provide Ms. Olson with that information in terms of the address. And we'll also modify the recommendation regarding that the guardian will defer to the children's counselor as to any contact with the mother.
Your Honor, I just wanted to make out one other point. For changing schools for these other schools or schools of choice, there are limited spots and they have to be chosen like prior to the school year. So I would just ask that if they can change, if you would just consider allowing them to change their school district.
Well, we need evidentiary hearing on that. And I'd like to see, wait for a month or so to see whether mother's progress increases. Ms. Sikorsky, let's assume that mother's condition does not improve. What's your client's position on, well, no one's representing the mother. but the,
Well,
I don't know if your
you
client
know,
would have standing on that issue as guardian of the mother. Would she have standing to object to a school change?
I think she does. She stands in her ward's shoes. And I also think it would require more information. I don't know what the therapist's take is on that. You know, Dad was able to transport to and from school up until now. He did have parenting time on school days. And sometimes it's inconvenient to be a parent, but you still do what's best for your children. And pulling them out of this environment where they have friends and their teachers know them just doesn't seem to be a really good idea at this point in time, given everything that's gone on in their lives.
Well, I would just like to point out it's a 45-minute to an hour drive each way. The girls will get more time each day being closer to a school around here where they are currently residing full time. And that, you know, allows them to do extra activities, sleep in. I mean, driving that far each day doesn't make any sense for the children at all. To be sitting in that car.
When do you have the children have to be registered for school, Ms. Neff?
I believe it's going on right now. Some of the schools have already booked up. So.
Okay. And where is Mr. Lavanos suggesting the children attend school?
Wyandotte, I believe it's Washington Elementary. They have a really good school district, or North Point in Southgate.
Well, I think he's got to determine which school, so we're not going back and forth to schools.
Or North Point then.
Well,
Right.
Dad can't even nail down what's best for his children. He's throwing out alternatives. It sounds like he wants anything but Triumph, and he hasn't shown that that's best for the girls.
That is inaccurate. He's
All right,
been.
the court's going to review this matter on July 31st at 8:30. We'll review school choice July 31st at 8:30. Mr. Lavanos should come back with a specific recommendation, and they should discuss that with the guardian. If in fact mother's condition has not improved, the court's inclined to believe the children can make that change. Mr. Gorski, certainly the court was not going to change the schools midstream. When this court decided to order back in April, the court was not going to yank them as requested by Mr. Lavanos at that time. Clearly not in the children's best interests. But with the new school year in the fall, that's a little bit different.
I appreciate that.
Your Honor,
If the children will be residing with the father, then it makes more sense to be closer to father's home. Now, this recommendation last indicates that father should have possession. Does he have the authority to make medical treatment decisions on behalf of the children? Should he not at least have joint legal? And I don't know what the last order said between these parents. I see. Oh, no, they've got joint legal equal parenting time. So that's not necessary. All right. So the rest of the recommendation appears to be satisfactory. Dad shall have possession of the children. Grandmother should have parenting time every Sunday, 10 to 6, beginning on June 23rd, 2024. We'll review the issue of school choice on December 31st, 8:30 a.m. Does that work with your schedule, Mrs. Gorski and Ms. Neff?
It does, Judge, and it's my understanding that the parties share joint legal custody. The children have state insurance, so he shouldn't have any trouble getting health care.
Correct. Yep, I note that. Okay. And obviously, Ms. Zgorski, you made a note of this. The children's counselor is Asia Stevenson.
Yes.
I'm not sure what agency that's with. Ms. Neff, what agency does she work for? Is she just self-employed?
Great Lakes.
Great Lakes?
Yeah,
Is that in Downriver area?
that is in Livonia.
Livonia.
I
Okay.
can provide the opposing counsel with the therapist information.
That would be appropriate. That would be helpful. Okay. All right. Is there anything further than this afternoon, Ms. Neff?
I don't have anything further, Your Honor.
And if there's issues with parenting time, we can address it on July 31st if need be.
Okay.
Anything further, Ms. Gorski?
No, thank you, Your Honor.
All right. We'll see everyone back on July 31st then, 8:30. Thank you, Mr. Brad. Everyone can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor. The new recommendations in your.
Court on the plaintiff's motion for reconsideration. The plaintiff being the Sarah Olson. I'd say the petitioner being Sarah Olson, and the guardian of the plaintiff, Mother Chanel Olson. Mr. Gorski, Attorney Ms. Gorski, is representing that guardian, and Ms. Sarah Olson appears to be present with Mr. Gorski. In addition, Attorney Corey Shimmick is present representing defendant Father Michael Lavanos. Mr. Lavanos is present. a way of history in this matter, the court originally entered an order, and perhaps the language of that order dated June 11th, 2024 was inappropriate because it did suggest that the grandmother, Sarah Olson, was granted parenting time, and that was inappropriate because there was no petition for grandparenting time. It was simply for the grandmother to facilitate parenting time between the minor children and the plaintiff mother, who is currently residing in a nursing facility here in Monroe County. The court granted the defendant's motion for reconsideration and struck the order of July 30, struck the order of June 11, 2024, which granted parenting time to Sarah Olson. Subsequent to that, the guardian, maternal grandmother, filed a motion to reconsider that decision. So we're back here to where it began. The court, Ms. Sikorsky's reference that she clearly was not asking for grandparenting time, so perhaps we simply need a clarification of that order. And the court notes that when the parties were back before the court on June 11th, the guardian, Sarah Olson, was to confer with the children's counselor as to the appropriateness of bringing the children to the nursing home in the presence of the plaintiff mother. So that seems to be the primary issue this morning. Has that been done, Ms. Sikorsky?
Your Honor, it wasn't clear who the children were seeing. Mr. Shimmick provided a report from the therapist yesterday, dated July 30. I believe he's forwarded that to Ms. Frazee. He sent it to.
Not seen it.
But my
Ms.
client
Frazee,
has not spoken to the therapist. She has not.
And Your Honor, I was unaware that your previous secretary had retired, so I emailed it to her by mistake yesterday, but I just forwarded it to Ms. Frazee this morning, the report from the therapist.
In any event, so that's the primary issue. The only the time that the children have contact with the maternal grandmother is to transport the children to the nursing home. Can dad do that?
Yeah, yes, Your Honor.
Can Mr. Lavonis take the children to see their mother once the counselor says it's okay? Perhaps we should say for the record, the plaintiff mother, I think, consumed some pills. Is that correct? And she overdosed, and now she's in a, and perhaps her condition is improving, but she was in a coma for a period of time. I don't know if she's still in a coma, and obviously that could be difficult for the children to observe their mother in that condition. And the children, as I recall, are 7 and 6 years old. Is her condition improved? Is it appropriate for the children to see their mother in that condition?
Judge, it was a suicide. She is not in a coma. However, she has not made a full recovery. There's a meeting scheduled for Tuesday of next week at 11 o'clock regarding her condition, and my client will know more at that time. She is responsive. For example, when my client talks to her about the children or things that are sensitive, she's aware of it and she will cry, but she's not engaged in a level where she could communicate, for example, to this court how she feels.
And Your Honor, my client would like to transport the girls to the visitations. And we did agree that he would not go in the room with them when the visitations do take place. But I think that we all agree that the girls need to be adequately prepared before the first visit, so that they're aware of their mom's condition or somewhat of what her condition is before they actually go and visit her. As of right now, they're aware that she is sick and that she's in the hospital. However, we do believe that the therapist, with the assistance of the therapist, they need to be adequately prepared before the first visit.
Can mother communicate?
Not verbally. Not verbally.
Okay, well, that's going to be difficult for a 7 and 6-year-old if you can't talk with their mother.
Right.
But would she, again, we don't even know if she would know they're present. In any event.
She would know that, absolutely.
Okay. Ms. Sikorsky, you're asking the court to reconsider. The court's inclined to deny the motion for reconsideration. You're asking that the court, not asking for grandparenting time, you're asking the court to make contact between the sisters, with the stepsisters.
Half sisters. Chanel is the mother to all 3 girls, and my client actually has guardianship over that third child, McKenna.
Okay. Have you discussed that with, does she and Mr. Lavanos have any communication?
They used to. This incident has definitely caused a rift, and Mr. Lavanos does not respond to my client anymore.
It's unfortunate, Mr. Lavanos, for the best interest of your daughters, that they should have a relationship with their half sister. But the court doesn't believe it has authority to order that, Mr. Gorski, so the court was going to deny your motion for reconsideration. Ms. Brown, if you could add that to with this recommendation that the defendant's motion filed on behalf of Sir Olson to reconsider the prior decision of this court is denied. The recommendation further states that the first visit between mother and children shall be arranged by the children's therapist. So she's going to arrange that, or she's going to recommend the contact. It's not real clear. She's not going to, the therapist is not going to take the children to the nursing home, correct?
Correct. The intention is for the therapist to prepare them for the visit and to recommend when the first visit shall take place.
All right. Perhaps we can reword that to Ms. Brown, if you could, please, that the child therapist, that contact between the children and the mother will be arranged by the plaintiff father upon recommendation of the therapist. Further, father shall provide transportation for the visit, will not be in the present in the mother's room. The children shall attend North Point Elementary School in Southgate for the upcoming year. Any objection to that? Well, Mr. Course, I'm not sure if your client has any objection to.
She doesn't.
To object to that.
No, Judge, she understands the need for the girls to be closer to Mr. Lavanos' home. And based on the therapist's recommendation that they could use services through a school that, and Triumph doesn't provide those services, she has no objection. She believes it's best for the girls.
All right. Thank you. And lastly, Mr. Shimmick, you're asking for a change of custody.
That is correct, Your Honor.
What's the current, is there a petition that's before the court?
Yes, our original motion as to why we are here included a request for change in custody.
All right. Mr. Gorski, you're, well, I guess, I don't know who's representing the plaintiff mother.
It would be, my client is her advocate. So I guess I'm counsel to her guardian, and the guardian has the authority to advocate on behalf of her ward, Chanel.
Okay.
I understand, obviously, physical custody and parenting time. Mom currently has no parenting time and can't, pending the therapist's recommendation. But I do oppose a change of legal custody because that would allow, as a practical matter, Mr. Lavanos to move to Alaska or to substantially change Chanel Olson's status or her ability to access the children and the children's ability to access her. And I don't believe that's in the children's best interest, particularly given his unwillingness to work with the plaintiff's advocate.
Understandable. And this court's opinion on physical custody. Right now, the parties share joint legal custody. Is that correct?
Yes.
Yes, Your Honor.
As a practical matter, that's it appears that the guardian, I don't know if the guardian, you have to research that. I don't know whether the guardian should have input on emergency medical decisions for grandchildren or not. But again, it's more parenting time. So what's wrong with this court? I can parties agree that the defendant father will be the primary resident of the children will be with the defendant father.
I don't have an objection to that.
Shall not change the domicile of the children without the consent of the court. What's the objection to that, Mr. Shimmick? We're going to spend a whole day arguing about that, and that's where it's going to go. I'm telling you right now.
I understand, Your Honor. However, with joint legal custody, my client.
This court does not have to decide joint legal. This court does not have to. Well, I'm sorry. Yes, joint legal. We'll leave that in place, but we don't need to argue about physical custody, do we?
No, we don't need to argue about physical custody because I believe there's, and for a practical matter, there's been a change in physical custody already with the parenting time. But in regards to legal custody, my client is seeking sole legal custody given the change in circumstances. And, as a technical matter, if there are any major decisions to be made, he can't go to Chanel mom and say, do you agree with this? So, what should he file a motion whenever there's a decision to be made, or, can he make that decision on his own? He's kind of stuck if he does not have sole legal custody. So, we are seeking sole legal custody in this matter, and that's why we asked it for an evidentiary hearing to be set.
Do you have any objection to a provision that the domicile of children shall not be removed from the state of Michigan without the consent of the court?
If sole legal were awarded to dad, are you?
Regardless of that,
That's
regardless of
situation.
that, do you have any objection to the court entering an order that the domicile of the children shall not be removed from the state of Michigan without the consent of the court?
Do you have an objection to that?
Yes.
All right. Right, to Mr. Gorski, as a brief these issues, does the guardian have the authority to make medical decisions on behalf of a grandchild?
Judge, I don't think that Chanel is in a position to object to decisions that Mr. Lavanos makes. I have two concerns, and that is, they seem to be founded based on the answer to the question that he just gave, that he intends to move these children away from their mother, and also that after 2 years, if she doesn't support or have contact, then she can be terminated and he can have these children adopted by another person. Those are my concerns, and sole legal custody would give him the ability to do that. I don't think that's appropriate. I don't think that that's fair to these children, and so I will brief that issue, and I will strongly advocate against sole legal custody.
All right. I guess rather than take an evident hearing, it appears to the court the primary issue, and even if the court awards joint legal, Mr. Shimmick, I'm sorry, if the court awards your client sole legal, there's nothing that prohibits this court from ordering that the domicile not be changed for state of Michigan. Would you agree?
Yes, I would agree, Your Honor.
All right. So with that, Mr. Gorski, I mean, I would ask that the parties think about that and confirm if in fact there's got to be some work with the language. The primary residence of the children shall be with the defendant father. The domicile of the children shall not be removed from the state of Michigan without the consent of the court. Perhaps I will address those issues. Perhaps we're making a lot of issues that don't need to exist. So at this point, rather than schedule an evidentiary hearing, do you want a date that Mrs. Gorski can I don't know if you want to, is there any value in mediation, or do you want to brief that issue in terms of, does the guardian of the children have the right to participate in medical treatment decisions on behalf, emergency medical decisions on behalf of the children in their capacity as a guardian?
I think there's always a benefit to mediation, Your Honor, and I think that these two people who love these children need to get on the same page about what is in their best interest. My client is always going to have to defer to dad, and she understands that, but I don't think that these children are benefiting from the current situation.
Should make an objection to mediating this issue of the change of custody?
No objection, Your Honor.
Right. Ms. Barr, do you have a list of mediation dates and times available? Perhaps
Yes,
Ms. LaPrade might be ideally suited to address an issue of this nature.
We have August 9th. It's a Friday, and in the afternoon. I know you prefer not to have Friday afternoons.
Yeah, this court will not be available. I'd like to be available. There's a MJA conference I'll be away at, so now I'll be out of the jurisdiction. Okay. I'd like to be present so I can confer with the parties after that mediation to, if necessary, schedule an evidentiary hearing.
I have Friday, August 16th in the morning.
I can't do that week.
No.
Yeah, let's look in September. Let's look in September. I don't think it's critical that decision has to be made in the next 30 days. So we'll look in September. It might give the parties more flexibility as to their schedules.
I have Thursday, September 12th in the afternoon.
That works for me.
I can do that.
1:30?
Yes, Your Honor.
That with Mr. Walker or Ms. LaPrade?
That's with Ms. LaPrade.
All right. All right. If you could just put that in this recommendation to Ms. Brower, and the court will be the parties should meet with Ms. LaPrade on that date and time, and subsequently appear before the court for review. If in fact there's no resolution, the court at that time will schedule a hearing, Mr. Shimmick and Mr. Gorski. But yes, the court's inclined, no matter what we do, is to order that the defendant father prohibited from changing the domicile of the children from the state of Michigan without consent of the court. I think that's going to be a starting point. I don't know why we can't, with that, work around these other issues.
Okay, understood, Your Honor.
Because, yeah, what if mother improves? We always hope that someone will improve their condition. She can be active in their daughter's lives.
Of course.
And, if dad's moving out west, I mean, that's going to destroy that. So with that, the children shall attend North Point Elementary School in Southgate for the upcoming year. For the prior order, the children will continue to be in primary possession of the plaintiff father. The court will deny the motion for reconsideration filed by Attorney Zagorski on behalf of the guardian, Sarah Olson. And father shall facilitate visitation of the children with their mother upon recommendation of the children's therapist. So obviously, Mr. Lavanos, it's important that as mom improves and talk with the counselor about the children, slowly talk with them about when's the right time for them to see their mother. And obviously you have to describe to the therapist the mother's condition, that she's nonverbal right now. At some point in time, children need to see their mother.
We've already talked to the therapist about it. We're kind of like working towards it.
Okay. And to try to keep an open mind too. Do they ask about their stepsister, their half sister?
Sometimes.
Well, maybe invite the stepsister over to spend a day with your daughters. I mean, you got to figure out what's best for your daughters, not what's good for you or what you personally feel, but what's best for your daughters. That's what you got to be guided by. So the court would encourage that.
Okay.
All right. Anything further than this morning, Mr. Gorski or Mr. Shimmick?
No, thank you, Your Honor.
No, nothing further.
All right. That concludes the matter. Thank you, Ms. Brower, for your assistance. I know didn't realize we had things every 15 minutes. So I know you're.
You're welcome.
Have a great day, everybody.
Before the court, substance parties have engaged in mediation this afternoon with Ms. LaPrade from the front of the court. Present for the Zoom hearing is Attorney Maria Zagorski, representing the guardian and maternal grandmother of the minor children, the Chanel Olson. Ms. Chanel Olson, the plaintiff being a resident of a local nursing home. In addition, Attorney Corey Shimmick is present representing defendant father Michael Lavanos. Good afternoon, everyone.
Good afternoon.
New Judge.
Progress and during mediation? Ms. Zagorski?
Well, Judge, the parties talked about having the sisters FaceTime, and Mr. Shimmick doesn't want to put anything in writing, and I'm not criticizing him for that. I think if I were in his position, I would take that same approach. We aren't able to agree on his request regarding legal custody, so I think we need to brief that so that the court can rule on his motion. At least I'm asking for a briefing schedule because I want to provide you with the authority to prevent that from happening. We did schedule the therapist for a deposition on Monday. Her attorney reached out to me today and said he's already scheduled for trial. He's not available, so we have to reschedule that deposition. And that's about where we're at. And please, Mr. Shimmick, correct me if you disagree with anything I said.
No, that's accurate.
So, Mr. Shimmick, your client is requesting sole legal custody. Is that correct?
That is correct, Your Honor. Yes.
Ms. Gorski, obviously, the plaintiff mother is not in a position to join dad in making medical treatment decisions or school decisions on behalf of the children. If the court went last and before the court, the court ordered the children can attend school in Southgate where dad lives. Obviously, mom can't knowingly, intelligently discuss and make decisions on those issues. So the court made notes that it appears appropriate, and I can hear testimony. We can go through and spend a lot of money that the sole legal custody should be awarded to the defendant father, but the court is reluctant to that the court wants some condition that the father cannot change the domicile of the children. I mean, you can't leave the state of Michigan. There's got to be a restriction on that so that the children are still available to be able to have a relationship with mom once the therapist believes it to be appropriate. So that's just the court's preliminary thoughts. I'm reiterating what I suggested before. If the court, that's some of my notes reflect.
And Your Honor, Mr. Luevanos has no objection in putting into an order that he cannot move out of the state of Michigan without prior approval of the court.
Judge, my concern is, well, first of all, mom, Chanel, is communicating. She's smiling, she's crying, she can hear, she can participate. And obviously you would need some verification from her care providers about her ability and level of participation. But my concern is that even with a prohibition against moving out of the state of Michigan, that once that motion is filed, I don't know that the court has authority to prevent him if he has sole legal custody. And we do believe that his end game here is to move to Florida with these children, which would, of course, terminate any relationship between the girls and their mother. Excuse, my client is turning off. She thought she had an alarm off, but she's got it off now. So that is the concern.
Yeah, but and of course, it could be some successor to this court, but this court would be loath to interrupt the schooling of the children at their age to pluck them out of the state of Michigan and the environment they're growing up in and send them to another state. But again, of course, that's always possible in the future. So of course, the court does have the July 30th, 2024 letter from Amanda Fritz, who's been counseling the children.
Yeah, Judge, she is the person that we plan to depose, and the girls in this case sent their sister a letter It was received yesterday, at least one of the girls did, saying, "I miss you so much." And so I think that there's more here than just, I mean, at the end of the day, it's always about the best interest of the children. And I respect Mr. Shimmick's ability to make his legal arguments, but I think that this court has to know all of the facts before we do anything. I'm just primarily concerned about these girls.
Well, Mr. Shimmick, let's say the girls need medical treatment. I mean, obviously, I don't know if mom's in a position to communicate effectively to share in that decision making. Is she, Ms. Zagorski?
I don't think like somebody has a broken arm and needs to be well, I think she should still be notified, but like deciding whether to get a vaccine or something, I think she could express an opinion, but I'm not sure how. It wouldn't be easy, Judge. I'll be honest with you. It wouldn't be easy. She's in physical therapy. They're working with her on communication, but I can't tell you that she could pick up the phone and have a conversation because that's not true.
Well, Mr. Levena should have to petition this court every time he's got to make a important decision concerning the welfare of the children, whether it's so in any event, you want to complete discovery. The court's not scheduled here until you complete a discovery. So I guess we can maintain the status quo and something to Mr. Shimmick. Once you complete discovery, you can notice back up for hearing if in fact you and Ms. Sikorsky cannot come to an agreement. You're both capable family law practitioners. Maybe you can come up with some language that would strike the balance. You know, obviously we always hope that Miss Chanel will improve, and so she can start to communicate effectively with her daughters, her children. But that remains to be seen.
Your Honor, I'd request a discovery cutoff date be set today, and then we set an evidentiary hearing date, so that we have the date on the schedule.
How much time do you need for discovery?
Judge, we need to reschedule the therapist deposition. Like I said, I just learned today that she's not available. It was scheduled for Monday. I told Mr. Shimmick I would circulate an email with him and the therapist's attorney to get that rescheduled as soon as possible. I'm going to need to get statements from mom's care providers. So I would need at least 45 days, I would think, possibly interrogatories, 60 days.
I would be fine with 60 days, Your Honor.
Okay, how about discovery till November 29th?
Thank you.
To prepare, Mr. Shimmick, prepare an order that discovery will conclude by November 29th, and we give you a date to come back for review in December. I'm not going to schedule an evidentiary hearing until such time as we've exhausted all efforts to resolve this matter, and you have for certain concluded all discovery. So we can give you a date if you want a date on our motion docket in early December 3rd or 4th.
I'm wide open both days. Sorry?
I'm open both days as well.
December 3rd, 8:30.
Perfect. Thank you, Judge.
Anything further this afternoon?
No, thank you for your time, Judge.
No, nothing further. Thank you, Your Honor.
You're welcome. Parties have conferred with front of the court this morning, who has recommended the father of sole legal and sole custody of the minor children. The father agrees not to move the children from the state of Michigan without prior approval of the court. I believe that was concern previously stated when the plaintiff initially filed the motion. I'm sorry, when the defendant originally filed the motion for sole legal custody, was that not to give the defendant father the opportunity to simply move from state of Michigan without the consent of the mother, and hopefully that mother will improve in her medical condition. Is Miss Chanel Olson still residing in a nursing home?
She is, Judge.
Okay. Have the children visited her? I believe that was, the court previously allowed that at the discretion of the children's counselor.
Judge, the court granted me the opportunity to conduct discovery, and I did try to depose the children's therapist to find out whether that was a good idea and what she recommended, but defendant father wouldn't sign a release, and so the therapist really couldn't provide me any information.
So the children have not seen their mother then? Is that correct?
That's correct.
Right. Ms. Sikorsky, is this recommendation agreeable with your client this morning?
Unfortunately, Judge, I don't think I have a choice under the law, and so the answer is yes.
Okay. Right. Ms. Neff, is this recommendation agreeable with your client this morning?
It is.
Okay. Is Ms. Chanel, is her condition improving where she can speak with the children?
It is not, Judge, unfortunately. My client is going to have another neurologist do a workup because she moved during her last scan, and so they didn't get a good read about her neurological activity. And so we don't really have any news to report.
All right, thank you for the update, Ms. Gorski. Anything further than this morning, Mrs. Gorski or Ms. Neff?
Yes, Your Honor. There were just two things. I requested the name of the court reporter that opposing counsel used for the deposition, so we can request a transcript. Opposing counsel does not want to provide that to me. I would like to be able to order a transcript from that.
Did your office not appear at the deposition?
We did not.
There's no notice provided?
I believe Mr. Shimmick informed them that he was not going to attend.
Okay. Ms. Gorski, any objection to provide the name of the reporter who conducted the recording of the deposition?
Yeah, yes, Judge. My client paid for that. They would certainly be entitled if I used that in an evidentiary hearing or if it were an exhibit. But at this point, my client owns it. As I indicated, defendant father didn't cooperate, didn't show up. He did have notice. He wouldn't sign a release. And so quite frankly, I'm not feeling very cooperative. My client did have to pay for that already. And so I don't feel that she should have to provide anything to him.
All right. Ms. Neff, what was the other issue?
The other issue is that my client had to pay $1,500 to the therapist for the deposition. And we would request that the opposing party pay that bill.
I'm sorry. First of all, this matter is not before the court this morning. I think you should file a motion and brief it. I mean, why would Mr. Levinas pay $1,500 for deposition but not have his attorney appear at the deposition? What am I missing?
The therapist is charging my client for it.
And was the therapist subpoenaed for the deposition?
I believe so.
Well, at this time, the court's going to adopt the recommendation of the front of the court this morning as to granting the defendant father sole legal and physical custody of the minor children with the understanding that he shall not leave move for the children to state of Michigan without prior approval of this court. Any other issues that need to be brought before the court by a proper petition and a brief? So the court will not address those issues at this time. Ms. Neff, perhaps Mr. Shimmick, or you can talk further with Mr. Gorski. If you can't reach agreement, you can file a motion with the court and brief the issue.
Thank you, Your Honor.
All right, that will conclude this hearing. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor.
Thank you.